If Nancy shows up later, we'll be glad to add her. The next person we have is Dr. Michael Ferris with Convention of States. Dr. Ferris, thank you for being here.
Thank you, Mr. Chairman, Ranking Minority Member, members of the committee. Thank you for the opportunity to be here. I am the co-founder of the Convention of States project, a lawyer, been in practice now in my 47th year. I've argued dozens of cases, constitutional cases in appellate courts, including the Supreme Court of Ohio, 2 cases in the Supreme Court of the United States. And I have litigated an Article 5 case on the amendment process back in the late 70s, early 80s, in a case that made it to the Supreme Court of the United States on the question of the extension of time on the Equal Rights Amendment. I represented 4 Washington state legislators in that case. So I'm one of the few lawyers in the country who've actually litigated an Article 5 case. I've also taught constitutional law at Patrick Henry College. 2 of my former students are now state solicitor generals, Indiana and West Virginia, and 5 of my students have clerked for the Supreme Court of the United States. I do that to say that a lot of lawyers claim to be constitutional lawyers, and my question to people making that claim is, show me the number of laws you had declared unconstitutional, and then we can talk. And so the constitutional issues in this case, sorry, I'm used to this, in this legislation can be addressed today perhaps by asking 3 questions. Why did the founders create the process that we're seeking to use here? The second question is, do the current circumstances that we face in our country align with that purpose and that process? And third, is the process safe? And I'll briefly address all 3 of those questions. It was at the end of the Constitutional Convention process in the last week where George Mason observed that the proposed version of amending the Constitution that was in place at the time had a blind spot. And that is, all amendments were going to be proposed by Congress and all would be ratified by the state. And his speech to the convention basically said, Congress is never going to propose an amendment that limits its own power. And the founders in that day probably said something like, we hold that truth to be self-evident. If they were around today, they would say like, duh, and meant the same thing. And they immediately proposed the change to Article 5 that we now see, to give the states the ability to propose amendments for the express purpose of limiting the power of the federal government if the federal government gets out of hand. That's the reason we had it. It was one more layer of the checks and balances process. We don't want any agency in government, we don't want any level of government having too much power, and the ultimate ability to amend the Constitution essentially unilaterally, not by one state, but by ultimately 3/4 of the states, was a check on the misuse of federal power. That's why we have this process. So that takes me to the second question. Do our current circumstances align with that purpose? Well, I could give you a couple hours worth of reasons that that would be true, but I'm going to do 3 and do them briefly. First, the debt. We are experiencing debt that's in the 30s of trillion dollars, and if it's not exactly there today, it'll be 40 trillion all too soon. It's just out of control by anybody's estimation, and that's calling the debt that's on the books. If you take off the book debts, like all the money that's been borrowed from the Social Security system and not paid back, the actual number is closer to $150 trillion, an unimaginable number. And we've done that by spending for things that are not within the competence of the federal government. And that all comes back to a Supreme Court case. If you want to know which case caused all this, the Butler did it. It's United States versus Butler, where the court said federal spending was not limited to the enumerated powers. If federal spending was limited to the enumerated powers, we would essentially have no federal debt. We would certainly not have the kind of federal debt that we're looking at today. I'll take a second example, education. Years ago, I was litigating a homeschool case in New York, and I walked from the State Department of Education, past the city offices, past the regional office called BOCES, down to the federal offices where the litigation was going on. And I realized that every single level of government that I had just passed had a Department of Education. We do not get more services for kids. My dad was a retired public school principal. We don't get more services for kids by having multiple departments of education. We get more bureaucrats. The founders never gave education as an enumerated power to the federal government. They take our money from the states, they take it to Washington, D.C., they send a small portion of that money back to the states with strings and effectively run the educational programs of the schools. About, on average, 5% of school funding comes from the federal government, and 55% of the rules come from the federal government. It is an out-of-control situation. If we returned that whole process, took it away from the federal government, reduce the power and jurisdiction of the federal government, we would have that problem solved on that particular issue. We're getting the feds out of it and get back to just state and local government dealing with education issues. Third example, one is a special favorite of mine ever since I ended up getting an LLM in Public International Law from the University of London, is the treaty process has just gone awry in our country. Our country adopts about 200 treaties a year. 95% of them never are sent to the Senate for ratification. Some years a little more, some years a little less, but the vast majority of treaties are signed either by the president alone or by the Secretary General of the no, not the Secretary General, but the U.S. Ambassador to the UN or some other diplomatic person. We call them executive agreements. That's a term that the Supreme Court and the State Department collectively made up. In international law, all executive agreements are treaties, but we do not treat treaties the way we do. The reason I do this, I'm sure you're getting inquiries from constituents about the upcoming WHO treaty that President Biden has indicated that he's going to sign as an executive agreement in April. And that treaty turns jurisdiction over from the states over pandemics to the federal government under the general supervision of the United Nations World Health Organization. And so that's the way treaties work. Under the necessary and proper clause, once a treaty's been adopted, then the power to implement that treaty goes to the agency that adopted it. That's the federal government, that's Congress. And so what we saw in the COVID pandemic, the states had the ability to vary their processes. We lose that under this treaty, and we lose it without so much as a vote in the Senate. We can stop the federal government from doing this end run around the provision of the Constitution that says all treaties should be ratified by the U.S. Senate by a simple fix that effectively overrides the case that the Supreme Court made on this, which was called United States versus Pink. So those are three examples of how we need to impose fiscal restraints on the federal government, impose limitations on the power and jurisdiction of the federal government. The third topic you'll hear about from others under the application that's before you is term limits on federal officials. I'm not going to address that separately. I'm going to address just briefly the third question: is this process safe? The original process that we were given was checks and balances against the federal government, but there are checks and balances built into this process that prevent this process from going awry as well. In order to have a convention, you have to have 2/3 of the states agree on a topic for the convention. The application that's in front of you has been passed verbatim by 19 other states. And Kansas is maybe 20, but that's a long story. But 19 for sure. And so there's no question about aggregation, but we can't add that to other treaties that have been, or excuse me, not treaties, but applications have been proposed over time. There have been 450 applications for a convention over the course of history. The vast majority of them are still valid and in effect. And if 34 applications on any old topic was okay, then we'd have had a convention a long time ago. That's never been the case. We've always had the rule that you have to have agreement on the topic. So when we get to 34 states, agreement on the topic, then you can have a convention. Well, what's to prevent the convention from changing the rules at the time? The question arises because the argument's usually made. The original Constitutional Convention was a runaway convention. They didn't stick to their topic. Why will this happen? Well, that's just simply a historical lie. That's not what happened. I wrote the definitive answer to that argument in the Harvard Journal of Law and Public Policy. You can get it online for free. I have a few copies here today if you'd like to see them or have them. And it's called Defying Conventional Wisdom, How the Original Constitutional Convention Was Not a Runaway. And if you put my last name Ferris in and the phrase define conventional wisdom, you can get it for free on the internet from the Harvard Journal of Law and Public Policy. The basic answer is the states called the convention, and here's what the states told their delegates to do: render the federal constitution adequate for the exigencies of the union. The phrase only amend the Articles of Confederation comes from a resolution by Congress that has the power and effect of a National Pickle Week resolution. It was basically Congress giving their opinion, because under the Articles of Confederation, Congress didn't have any power to call any conventions. They had very limited power. And so the states called the convention. They told them to render the federal constitution adequate for the exigencies of the union, and that's what they did. The idea that they were only supposed to amend the articles is a flat historical lie that defames the Constitution of the United States. People who call themselves constitutionalists on the one hand, and then claim the Constitution was a result of a runaway convention, are engaged in intellectual schizophrenia at a pretty deep level. The checks and balances say, start with 2/3, agreement on the subject matter. And then you go to the convention. It's one state, one vote. It can't be proportional representation because that's a Congress, not a convention. A convention of states, every convention of states that has ever been held in this country, and there have been many, it's always one state, one vote. In fact, it's a term of international law. Every international convention is one state, one vote. We call them states in international law. And that phrase carries on. It's one state, one vote. That's a structural change. But 26 states, a majority at the convention, can approve a proposed text. Then it goes to the state legislatures. 38 states have to ratify. Now, that means if a single house in 13 states vote no, it's over. You lose, because it requires 38. So 13, one house going off and saying, no, we don't want this, that defeats that state. So 13 no votes in 13 chambers, we're done. The only way you can do this is if you have a sensible amendment, because it is very hard to do something good in this process. Very hard. Not impossible, but very hard. It is impossible to do anything crazy. Just you can't get it done. The structure that's in place is so solid. You cannot do something crazy. Now, there are two kinds of groups that are saying the opposite. One on the far right, one on the far left. On the far right, they're basically functional anarchists. They don't trust any government whatsoever. They don't trust this government. They don't trust their city council. They say every government's illegitimate. They're all doing the wrong thing. It's all bad. We can't run a country with functional anarchists in control. Just doesn't work. And they're saying that the checks and balances won't work because they don't trust any government at any point in time. The other group on the left, they're people that love centralized government. The more centralized, the better it is, including world government. They love things like turning over our pandemics to the federal government under the supervision of the UN. And so those people are also singing this runaway convention. You can't control it. You can't control it if your goal is functional anarchy. You can't control it if your goal is massive centralized government. Their arguments flow from their premises. Their premises are dangerous to this country. We do not want functional anarchy. We want a nation that works. And we do not want centralized runaway government. And that's what we've got in Washington, D.C. right now. We need to do the kind of government that works. That is a constitutional republic where there are limited powers at each level of government and there are functional checks and balances. The founders of this country gave every member of this committee and every member of this legislature authority to act. With that authority to check the power and abuse of the federal government, I suggest that you have the moral responsibility to do so. I would encourage you to vote favorably in this legislation. And I'd be happy to answer any questions that anybody might have.
Thank you for your testimony. Representative, again, with the question.
Thank you, Mr. Chairman, and thank you, Attorney Ferris, for being here today. Certainly appreciate you bringing, your testimony with regard to HJR 3. I want to say you brought up a lot of different points, some that, specifically relate to the joint resolution, but then some that don't necessarily, but also just provides some imagery so that we all could understand. So again, just want to say that I appreciate that. You brought up a point about, is this safe? And I appreciate that question, but it led me to start thinking in another direction. So my question for you is, with regard to like the state legislatures, do you know if within this bill there are any safeguards so that we can kind of oversee some of the processes and all of that as it relates to the conventions and actions and things like that? So any input you could provide, I would appreciate.
Certainly. There are a number of states that have passed pieces of legislation. Some are doing it as legislative rules that give the state legislature authority to control the actions of your delegates. They are meaning yours, not just Ohio's. They are the Ohio state legislature's delegates. They represent you. And so just like at the original convention, at the original constitutional convention, New York gave its delegates the instruction, all three of you have to be present to vote for New York. If you're not all there, you don't get a vote. Two of them got mad in July and left. Yates and another guy left Alexander Hamilton there. Hamilton debated, he never voted again because the state's instructions wouldn't let them do it. Delaware gave their delegates instructions that said, you can't agree to a government that denies the equality of the states. That's where the US Senate, the compromise came in, is because Delaware couldn't vote for it unless there was equality of the states in some important fashion. That they thought that the Senate was the fulfillment of that, and that's how we got an important factor in how we got the bicameral legislature. So yes, states can and are in this process giving their delegates instructions. You can give them a variety of instructions. We have model rules, we have model legislation on that, and yes, you can control them entirely.
Other questions for the witness? Representative Brown.
Thank you, Chair. Article 5 of the Constitution states, and I'm just going to read it so that there's no mistake.
Okay.
The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes. Now, if I heard you correctly, you were talking about the convention will be limited to a topic or certain topics. Doesn't this language fail to impose any limitations on any topic which may be raised in a constitutional convention under Article 5?
The question is, what constitutes a call? I'm a constitutional originalist, and so the question, the phrase that's there is the word call, shall call a convention. What is it? One of the factors, a call of a convention contains three things. It contains a subject matter, it contains a date, and it contains a time, a place rather. So a call will have those three elements. The topic, the lessons of history, if we've had 450 applications, and if it didn't matter what the topic was, we would have had a convention on all kinds of things. For example, right now today, if you add the plenary applications, mostly coming from the 1700s and 1800s, but there are 13 active calls for a plenary convention today. That is a convention that can consider anything. And you add them to the number of right to life amendment applications that have been exerted. You could have a convention on right to life right now, today, but you can't add them. The same thing is true. You could add them together and get the 16th Amendment reversed. You could add them together and get one man, one vote reversed at the state level. There are all kinds of things if you add them together, but that's not the rule of history and that's not the rule of law. Legislative history is part of what the word call means. And we have definitively settled as a matter of legislative history. We have multiple times had the necessary number for a call if subject matter didn't matter. Now, the litigation that I did in the ERA case held, and recent court decisions have affirmed that case. That is, you can't change the rules in the middle of the stream. If you start out saying you're going to have 7 years for ratification, you got 7 years for ratification. You can't change the rules in the middle of the stream. And the same thing is true here. If you start a convention for the purposes of the 3 topics that we have here, you can't change the rule and add a 4th or a 5th or a 9th. You stick to the topics at hand. And that's the way it's always been, and that's the way it will be.
Follow?
Thank you, Chair. So is it your testimony that there is no possibility that if such a convention were called, the proceedings could evolve from a mere suggestion to amend the Constitution into a proceeding where the Constitution may be totally eradicated and replaced by an entirely new Constitution?
That cannot happen, Mr. Chairman, I'm sorry, Representative Brown through the chair. No, it can't happen as a matter of pragmatism and as a matter of law. The matter of pragmatism is whatever comes out of this convention, whatever comes out, has to be ratified by 38 states. Because we're not operating outside of the Constitutional Convention process in Article 5. We're operating within it. If the states, using the power, the implied power of the Declaration of Independence, basically held a revolution and said, we want to have a new thing altogether, and enough states showed up, you could try to do some kind of radical exercise like that. That can't happen inside the Article 5 process. You have to have 38 states ratifying. And anybody that monkeys with the First Amendment, the Second Amendment, the 13th Amendment, the 14th Amendment, the 19th Amendment, lots of amendments, lots of provisions, the separation of powers, the 2-term limits on the president. There's lots of things that would be so clearly voted down that we don't have to give them serious consideration. It's just, we have to breathe and take a little bit of common sense to it. Moreover, if somebody tried that, I personally guarantee, I at least will file the case and challenge them. I filed the first case against the abuse of the ERA and I won, and I'll do it again if that happens.
Follow.
Proceed.
Thank you for your response. I appreciate it. I have some questions about how this would operate. A convention, for example, with regard to the selection of delegates to a convention. I suppose one option would be to let the state legislatures choose delegates from their state to the convention. Another option might be for Congress to require elections for delegates, which could occur in either nationwide, statewide, or perhaps House district races. So what is your understanding or your belief as to how delegates to such a convention would be selected?
They will be selected by the legislature. That is a certainty. Because what it is a convention of states. That's what the founders called it. The first application was from Virginia in 1788. Even before the Constitution had been ratified, but the government wasn't operational. And they called for a convention basically to give us the Bill of Rights. And in that document, they call it a convention of states. That is a term of art that has a fixed and knowable meaning. And it's the legislatures that do the calling through, they do the application. The states control the process, just like the convention they came out of. I gave you the examples of New York controlling its delegates, Delaware controlling its delegates. It is the delegates of this state legislature. There is no doubt about it. Can people argue anything? Sure, they can argue anything. The likelihood of that happening is the likelihood of President Biden appointing me to the next vacancy of the Supreme Court. I mean, yeah, I guess it could happen, but you can bet anything you want to bet, and that ain't going to happen.
Final question.
Proceed.
If I may. Thank you.
Because I thought you were going to be the next appointment to the U.S. Supreme Court.
No. My final question, sir, is, and I think this is somewhat related. Would each state be represented equally at the convention, or would there be some kind of, would each state be proportionally represented based on population?
States meet one state, one vote. You can send as many delegates as you want. Our recommendation is you send 5 or 7, an odd number, so that they would effectively, just as at the original convention, caucus together, and whoever had the majority within your delegation would cast Ohio's vote. And so, but it's one state, one vote, caucusing. There are dozens and dozens of state compacts, interstate compacts. And every interstate compact that I've looked at, and I've looked at everyone I know to look at, and every single one of them has the equality of the states as the means of voting. Some of them do it by giving the same number of delegates to each state, and the delegates can vote independently. Other states, they use the one state, one vote system in some kind of variation, but it's equality of the states is the absolute rule for every interstate compact in the country that I'm aware of. And so we would be following that. And there's the Interstate Commission for Uniform Laws that gave us the Uniform Commercial Code and many other things. It's one state, one vote. That's effectively exactly parallel to what would be happening here.
Thank you.
Representative Swearingen with the question.
Thank you, Mr. Chairman. Thank you very much for your testimony. My question was just, and Representative Brown kind of touched on this, the selection of what I understand to be one delegate from each state to the convention would be selected by the state legislature. I'm assuming that would be the House and the Senate. And could you maybe elaborate on what the process might look like? Would there be resumes submitted, vote, how would that occur? Thank you.
Mr. Chairman, Representative Swearingen. A state could, if you wanted to have one delegate, I would not suggest it. Your state gets one vote as a unit. And so you could, if you want to send 50, I wouldn't recommend it. It wouldn't be fiscally responsible and create a lot of problems, but I would recommend 5, 7, some number like that. And the House and the Senate would have to collaborate on the process. We have a set of model rules on how to do that. And the best framework for doing this is, we believe, rules, not legislation. The reason for that is that there have been multiple cases going to the Supreme Court on this point, and that is Article 5 power is held by the state legislature, not by the state government. The governor has no role in the process of Article 5. And so ordinary legislation, the governor signs it. This resolution that you're debating today, or considering today, does not go to the governor. It's this, and so legislative rules can control the process in a fashion that can't really be challenged. And so I would suggest that as we get close to the convention, as we get close to 34, we're at 19 right now and moving, that as soon as possible, but certainly by that time, adopt joint rules that clarify the process. We have models for you to consider. It's really pretty easy. I mean, a lot of states are doing things like the leadership of each house recommends 3 people, and then there's a process for getting the 7th. It's the kind of thing you do for creating commissions and joint study things on a pretty regular basis. It's not unusual.
Continue.
Just a quick follow-up. In your opinion, would you advise that the legislature put rules on those? Let's just say they went with 5 or 7 delegates to the convention. Should the legislature put rules on those individuals on how, almost like bylaws of how they're to conduct themselves or make decisions while they're at the convention? Or do you advise just leaving that open-ended?
Mr. Chairman, Representative Swearingen, the model rules we have, I would say, a moderate degree of control. For example, one of the things that we've suggested is that the group name one person as a spokesman for the state of Ohio, that you don't have all of them going off and spouting this and that and the other thing. You could adopt that. You don't have to adopt that. But that's the kind of thing you could adopt. And so you can, but I would not want to tie their hands so that they, every single little thing that they're doing, they have to come back here for direction or guidance. But I would put some big pieces in place, and there, we have some suggestions, but there could be others. The hearing process of adopting such rules would help clarify some ideas that I think would probably be for the better overall.
That's very helpful. Thank you.
Representative Skindell with the question.
Thank you, Mr. Chair. I want to return to the line of questioning that Representative Brown had, which is this provisions found at line 67 through 68 8 in the resolution dealing with one state, one vote. You claim that it's equality of the states is something commonly used in some compacts. I find this provision very troubling because equality does not necessarily mean that it's fair for the citizens. So Wyoming, for example, which has a population of 580,000 people, would have the same vote as state of Ohio, which has nearly 12 million people. So you're watering down the influence of the people of Ohio. They have less of a say-so by population. I find that concept troubling and unfair for the citizens of Ohio.
Mr. Chairman, Representative Skindell, the exact same criticism can be leveled at the U.S. Senate because it is based on the equality of the states. And we represent, the House represents population. Population is an important component of our government, and one House is dedicated to that. Both houses in this chamber are dedicated to, or are divided on a very strict population equality basis. But it's not the only consideration. And it's one state, one vote on the ratification process. That can't be doubted. Wyoming has the exact same voting power as California on whether a constitutional amendment is ratified. It's just the structure of a federal constitutional republic. If we are a pure democracy, and that was the way the Constitution was written and the way the government was framed, and that was the only guiding star principle that we were to follow, then your critique would be well taken. But it's not the only principle, and we're not starting from scratch. We're not writing the process freshly. We're not deciding what should they have done. We're following the rules that they did create. And the rules they did create gave a role to the states. It takes 34 states to call the convention. That inequality that you talk about is bound up there. It takes 38 states to ratify. The quality that you criticize is bound up there. And it's the same thing at the convention. It's states, states, states at every level of the process. It's equality of the states that's inherent in the process at all three stages. And whatever equality in that is to the nature of a constitutional republic, just like the U.S. Senate.
Mr. Chair, follow-up. So you say it's in the structure and it's in the rules. The problem is this application is setting forth the rule. We are creating an unfair situation by requiring equality of the states that have been held to. And we don't have full equality of the states in the Congress because, again, as you mentioned, the House of Representatives is based upon population. So there's a consideration of both. This particular application does not consider both situations, and it leads to unfair situations for the people of Ohio.
Mr. Chairman, Representative Skindell, if, again, we were writing the process fresh, we could debate whether this was a good idea or a bad idea. We're not there. We can't debate whether the Electoral College should exist or not. We can try to change that. You can change the process for it, but that's the process we got. States matter in electing the president. There is equality built into it because every state legislature that controls every step of the process is based on equality of population within the state. So the voters of Canton don't have more influence than the voters of Toledo, or take any other two places you want. There is equality within the state that is guaranteed as the structure of the process. But if you want us to jettison the equality of the states, we've got a lot of things to jettison. We've got to get rid of the Electoral College. We've got to get rid of the U.S. Senate. We've got to get rid of the entire process of amending the Constitution of the United States, not just one element of it. And so if you think the process is unfair, then the thing for you to do is to call for a convention of the states to change Article 5 to require proportional representation at every stage of the process. There's a way to write that to do that. And if you can get 38 states to agree with you, more power to you. But until then, it's the structure that the founders gave us, and the wisdom of it is for history to decide.
Mr. Chair, follow up. So the structure of the convention is being dictated by us, not some 200 plus years ago by the founders of this country. We in this resolution are saying one state, one vote. We can change that. We can debate that now so that when amendments are proposed and there's discussion at the floor of the convention, there's fairness in the system, not equality of the states, which is unfair to the people of Ohio. My other concern about this, equality of the states proposal, is that the majority of the states have a lower population than Ohio, and they tend to be less diverse. The more populous states tend to be a little bit more diverse. So when you have this equality of the states based upon just the states, you're weighting it towards a white population and discounting the various minorities, the ethnic groups, and the racial groups within this country. And again, it's unfair. It's unfair to the citizens of Ohio.
Mr. Chairman, Representative Scandell, what is being done in this resolution is not creating law. Ohio cannot dictate the rule for the convention. Ohio can dictate to its delegates how they're going to vote. That's it. And so if 26 states come to the convention instructing their delegates to affirm the natural process, that is, it's one state, one vote, vote's over. Because that first vote is going to be taken one state, one vote, whether anybody likes it or not. That's how the first vote will be taken. And I'm certain that there will be an attempt to change that. I mean, California will make the motion, New York will second it. Interestingly, Texas and Florida, I can pretty well guarantee you, will vote against it, even though they're two of the very most populous states. And so the suggestion that you're creating anything is like this legislature citing a rule of common law as you're making a piece of legislation. You cite pre-existing rules on a regular basis, and this is no different. You're reciting the reality that that's how it is, and you're going to make sure that your delegates are not going to engage in some kind of rebellion that's going to just waste time and end up being defeated anyway.
Representative Thomas with the question.
Mr. Ferris, thanks for being here today. Thanks for your testimony. My question is about Texas, and most U.S. citizens would like look at the situation in Texas and would like a solution to the standoff between the state and the federal government. How could a convention of states propose an amendment to fix this issue?
Mr. Chairman, Representative Thomas, well, there are two different paths. One is you could do a standalone application that would just address the border situation, and you could call a convention to say, we'd like a convention to solely address a remedy for the border crisis, and then you would have a convention on that topic. Under our application, since it makes germane things that reduce the power and jurisdiction of the federal government, an amendment that would give states joint jurisdiction to pass legislation to control the border within their state so that you wouldn't have automatic federal supremacy. You could give Texas the right to control Texas's border jointly with the federal government. You could give, and if the feds didn't want to enforce their law, okay, that's fine. Texas can enforce its law. And so that would be germane under our application. So at least to that extent, it would be appropriate. You could also, under our application, if you wanted to say the United States does not have the authority to give asylum to people who came here illegally, an amendment could be crafted for that purpose. That would be germane. Do I think that is likely to get out of the convention and get ratified by 38 states? Not very likely, but it's just an example of what could happen. Although I think the first example I gave you could get out and could get ratified, where you give joint jurisdiction to the border states so that they can control their borders.
Representative Swearingen with the question.
Yeah, thank you, Mr. Chairman. Vice Chairman Thomas just said on my question, because not only is our spending just wildly out of control at the federal level, we have a wide open border too. So thank you for speaking on that. My question was going to be, what can we do about the border at the Convention of the States, and I think you just answered that very nicely.
Thank you.
Thank you for your testimony. I have one quick question. And first, I've heard hours and hours of testimony on this issue in the past, and probably have heard you testify in front of me at various times. But functional anarchist is a new term. I appreciate that. I've been thinking about that all the way through your testimony, thinking about the people I know and friends of mine who are now functional anarchists. So I'll have fun telling them that. And not sure whether it's a compliment or picking on him, but my question is, so 38 states need to approve this exactly in the exact form on all three of these issues, correct? And right now 19 have, but it has to be exact, the resolution has to be exactly the same in all 38 states. Is that correct?
Almost, Mr. Chairman. The application phase, it's 34 states have to agree on the topics. And probably you could get away with minor variations on the topic. We're not taking any chances. Every state that has done this has done it verbatim on the operative language, not on the whereases and all the surrounding. But the operative resolution has been precisely this. Frankly, I got into this by going to a meeting in Denver 12 years ago, we'll call it, where we're looking at the BBA, Balanced Budget Amendment applications. And I looked at all the various forms of it, and I go, you guys we'll have a real aggregation problem, because they've been written in so many different ways. And, you know, many of them, for example, say, we want to hold a convention to call for this particular amendment. Well, that doesn't aggregate with anything other than calls for that particular amendment. The best way to have done it is just say, let's have a convention on balanced budget amendment. But only like 6 states have ever done that. So I spoke up at the meeting and says, why don't we just start over and do it right? And that's where the Convention of States process was born, was on my suggestion, let's start over and do it right. And as long as we're fixing it, let's fix it. Because if you just say balance the budget, it doesn't say you're going to control the spending necessarily, because the mechanisms to do that may or may not be present in a balanced budget amendment. But controlling the spending is the game. And the real game there is to get them to go back to spending for the enumerated powers. If you're spending on things that are outside the enumerated powers of the federal government, we're always going to be in this crazy broke situation where we're trying to fund everything for everybody. It's unsustainable, and our country shouldn't have to put up with it anymore.
So one quick follow-up.
Yeah.
So if, we trying to pass something through the legislature, right. I expect there's several different beliefs amongst probably even this committee, but certainly the legislature as a whole on those 3 topics. Some of us may strongly support 2 of them. Some may support all 3. Some may support 1. If we as an Ohio legislature were to craft one that said, we agree with 2 out of these 3, and other states agreed with 2 out of the 3, can we just do, would that count towards doing 2 out of the 3? Or does it, or would you have to start over with everybody just doing 2 items?
Mr. Chairman, the best answer I give you is we throw dust in the air when we don't need to. And so it creates uncertainty. We'd have to litigate that, frankly. And I don't want to have to litigate. I mean, people can file a lawsuit that's just nuts. I want to eliminate reasonable litigation. And so I would make an observation and a suggestion. The observation is we're agreeing on an agenda, not on an outcome. And so, I mean, I'll tell you from testifying in I don't know how many state legislatures now, lots. One of the most popular ideas in our application among people is term limits. The least popular idea among legislators is term limits. And so, there you go. Now, who's going to ratify this at the end of the day? Legislatures are going to ratify it. And so if a term limits proposal gets 26 states to vote for it by delegates appointed by the legislatures, it's going to go out, and then the legislatures, you're going to get 38 states to vote yes? My guess is that's going to be a big uphill battle. And so whether that one happens or not, I don't know. Now, my suggestion would be, what you could do, and what I would ask you to do if you're considering something like this, is to pass it verbatim and then instruct the Ohio delegates to not vote in favor of any term limits proposal. Other states have done that exact thing. And so you're keeping the resolution so that there's no aggregation problem, but you're bending the course of the discussion in a particular direction that, if that's your concern, you can bend the course in that way.
Representative Humphries with a question.
All right, thank you, Mr. Chairman. And again, thank you for hanging in there. Lots of questions today. I'm going to be brief. My question is, and I think you touched on it, but I'm going to ask it again. We're talking about topics discussed at the convention. And my question is, I know that there might be like a wide variation, but what are some of the topics that would be discussed at a convention by the delegates? Because we know the language is sort of vague. So just real quick, just wanted to know.
I'll give you 4 examples of things that I think can have political, realistic ideas behind them, and they're not crazy. One would be a single subject rule on Congress, to say that they get rid of these multi-thousand pages of omnibus bills that throw everything in the kitchen sink in them. No, one single subject. 41 states have a single subject rule. Congress should have a single subject rule. I think that has legs and could get ratified by 38 states. The treaty idea that I said earlier, that all treaties have to be ratified by the Senate, I think that has value and could get ratified by 38 states. I think that limiting the power of the federal government vis-a-vis the Department of Education is going to be a closer call, but I think that you probably could box the federal government out of the education business, not counting military education, not counting the District of Columbia, but vis-a-vis the states, you could box the federal government out of education, and that has a better chance of being ratified other than, some of the other topics. I would like to fix the Commerce Clause and the General Welfare Clause to go back to the original meanings of both, which is if the states can regulate it, the federal government can't. If the states can spend money on it, the federal government can't. That's the original meaning of both of those clauses. And 99% of the way the federal government has gone awry is violation of those 2 clauses. And so that's my ideal, but getting those ratified, that's a tougher chore. And so, but those are some examples of things I think are realistic.
Representative Brown with a question.
Thank you, Chair. In Ohio, our Constitution does provide for a single subject rule, which we ignore all the time. We just did ignore it not too long ago, which I pointed out on the floor of the House. I've pointed out many, many times. So I don't think the notion that we can have a single subject rule is really going to provide any real guardrail at all, because we have it here and we ignore it with impunity.
Mr.
I
Chairman,
think
may
that was a
respond?
statement, not a question, but you're welcome to respond.
With impunity?
Mr. Chairman, Representative Brown, let me write it and I'll fix that problem. Because, the easiest way is I would write into it taxpayer standing to challenge any litigation, because the biggest problem with violations of those is who has standing to challenge the violation of the rule. If you put right in a rule that says any taxpayer of Ohio has standing to challenge the violation of the single subject rule, all of a sudden you got a real rule. And you could do that at the federal level as well. And there might be other things that we could do. We need to study that, why this has been abused in some states. And you're not the only state that said that. But I think you could write it correctly because it is a good rule. And your frustration tells me you agree with the idea that it is a good rule. It should be used. And so you and I work together. We'll get it written correctly.
Thank you for your testimony. I appreciate you being
Mr. Chairman,
with
thank you
us
so
today.
much.
Just for clarity, and so everybody knows that we have 18 more presenters that I know of. That one took 45 minutes. I'm fine with that all the way through the rest of the day, but we finish about midnight, 1 a.m. I'm in if that's what you want to do, but collectively, if we can condense our comments, shorten our questions and our answers, we'll be in good shape. And I think we will be. They'll go faster after this one. The good individual took most of the questions, I expect. So the next presenter we have is William Scott. Is Mr. Scott available?
I certainly am.
Thank you for being with us.
Thank you. And Good afternoon. I had written down good morning, but as you said, it's now afternoon, so good afternoon. Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. As I said, my name is Bill Scott. I'm from Dayton, Ohio, and House District 38. I serve as the State Director for Convention of States here in Ohio. We're a nationwide organization, nonprofit with over 5 million supporters, and more than 2.5 million Americans have signed our petition for the Convention of States. Right here in Ohio, we have 113,000 of those who have signed the petition. Today, I'd like to talk a little bit about the purpose of the Article 5 Convention and why it's in the Constitution. The founders established 3 branches of the federal government with checks and balances to limit powers of each branch. They also check powers by wisely balancing it between federal and state governments. That balance of power is called federalism. And unfortunately, that balancing check is now nearly gone in our country. And why is that? Because for many decades, the states have failed to push back against the federal overreach by asserting their own constitutional powers over centralized federal power grabs. As the power in DC has grown, America's trust in federal government has declined. According to a 2022 research article by Pew, in the 1960s, more than 70% of Americans trusted their federal government to do the right thing just about always, maybe not always, but they trusted it most of the time. Today, that's only 20% of Americans think the federal government can be trusted. This finding holds for both Democrats, Republicans, as Americans have become more and more dissatisfied with an extremely bloated and overreaching federal government. As Dr. Ferris mentioned pretty well here, Article 5 of the Constitution was designed to ensure that that balance of power between federal and state governments remains in place. And with Article 5, the states can rebalance those powers using their ability to propose amendments. With the states proposing amendments to the Constitution, it's important to recognize the distinction between the Constitutional Convention of 1787 and what's being proposed here today in HJR 3, which is simply a meeting of countrywide state legislators to propose limited amendments. The Constitutional Convention of 1787 was obviously not called under Article 5 of the Constitution because it didn't exist yet. It wasn't written. Opponents of convention states often try to confuse and scare people by conflating 2 different types of meetings. An amendment proposing conventions is not a constitutional convention, or a con-con, as many opponents call it, in a rather pejorative way, I might say. The Constitutional Convention of 1787 was not called under the Articles because the Articles made no provision for any such convention. Instead, it was called under the reserved sovereign authority of the states. The states were completely sovereign at the time our Constitution was adopted, and the Articles of Confederation recognized that they had the power to write a new Constitution. They had that power to draft a new system of government, and that's what they did in the Constitutional Convention of 1787. That's not what HJR 3 does. What this resolution does is use Article 5 of the Constitution to allow the states to exercise the same power that Congress has every day to propose amendments. No different. They can propose amendments any day of the week, and they do. In just 20 words, that's what Clause 2 is all about. It says, and I won't read it again because Representative Brown has already read it. So as of now, 19 states have passed virtually identical and operative language in Ohio in HJR 3. If it's passed, along with a companion resolution in the Senate, we could become the 20th, 21st, 22nd state. Our United States Constitution is the world's longest surviving written charter of government. The unrestrained growth of reckless spending by our federal government places our country in an extremely dangerous position. If we don't put a stop to the financial recklessness of DC, inescapable monetary forces will do it for us, throwing the economy and our way of life into chaos. The worldwide consequences would be, I dare say, devastating if America collapses due to its own self-inflicted wounds. As legislators in Ohio, you have the authority and the responsibility to check the federal government, and each of you took an oath of office to defend and support the Constitution. So your support today in HJR 3 can help fulfill that promise. Thanks for the opportunity to testify, and I do appreciate it. And I'll attempt to answer any questions, and Dr. Ferris can assist me if necessary.
Thank you for your testimony, Representative Graham, and welcome to the committee. Representative Graham, glad to have you with us with the first question.
Thank you, Mr. Chair. Glad to be here. I had to step out for a minute for the last testimony, but I apologize if this was asked before. How are the delegates to the convention selected? Because I don't think that's really clear on what I've heard. I know how the representatives for the state and the federal government are selected. They are elected by the voters. But how are the delegates selected for the convention?
Right. Well, each state is responsible at the state legislature level to select those delegates, and it's up to the state legislator group, the Senate and the House, to decide how they're going to do that. Many states, and Ohio eventually will be one of those as well. We have a draft we can share with the committee or our sponsors or anybody else. A draft of, it used to be called faithful delegate selection, meaning we want faithful delegates. I think we call it model resolution for selection of delegates, something along those lines. But that is a document that gives some guidance, and you can modify it in any way, shape, or form. Some will say, let's get a joint committee together of House representatives and Senate representatives. Leadership appoint somebody, rank and file appoint some. They'll come up with ways to put a committee together. Or perhaps they'll vote on it as a caucus. Both caucuses come together. But it's going to be up to each individual state legislature how they select those delegates.
Follow?
So how do states decide how many delegates to send to the convention? And I'll let you answer that one.
Yeah, that's fine. That, again, is going to be directly up to the state legislatures. Dr. Ferris had mentioned, I guess, when you were out of the room, that he would recommend anywhere from 5 to 7, just an odd number. So as a group, you're going to get one vote as a state. But within your little group for the state delegation, it's good to have an odd number if you take a vote and 3 or 4 and 4 against, and so forth. Wouldn't recommend sending just one person, but you could send 3, you could send 5, you could send 7, you could send 50, but you still get one vote. So that's going to be up to the state. But we think most states will send about 5 people.
Continue.
So that kind of leads to my next question. I could really see an imbalance of how folks are picked with the delegation, especially in states with supermajorities and things like that. So how can we ensure a fair process to pick people to go to the Convention of States? I think a lot of my colleagues had mentioned, like, we have issues with Wyoming, for example, as Representative Skindell said, only has 500,000 residents, but we have almost 12 million. So we're selecting 5 to 7 people. Wyoming's maybe selecting 7 to 9 people. They do get one vote, but I feel like they might get more of a voice there because they have more people. So how do you ensure a fair process around picking delegates?
Yeah, well, it's a balancing political act, I would have to say, and that you negotiate just like you negotiate every day on bills in the House and Senate. And I would say there's you mentioned a supermajority. Ohio is not the only one with a supermajority. There are supermajorities in other states that have supermajorities going the other way. But in the end, we want something that is achievable to come out of this convention. By achievable, I mean 38 states have to ratify it. So if you put all Democrats on your committee or you put all Republicans on your delegation in all the states, you're not going to get something that's reasonable or approvable or ratifiable in all the other states. So I think there's a built-in self-guard there that it's in the interest of whoever this committee is. It may not be a committee, but it probably would be a committee, a joint committee, to have bipartisan representation, different points of view. And that's kind of how we expect it might happen. Dr. Ferris, did you have anything to add to that? Okay.
Representative Skindell with a question.
Thank you, Mr. Chair. I'm curious, as state director to the Convention of States, I was wondering if there have been meetings, telephone discussions. I don't know if you meet annually as state directors, but if you've had the opportunity to discuss the three topics in these applications, and I'm more concerned about the second one, which says that amendments limiting the power and jurisdiction of the federal government, because to me that seems to be broad and ambiguous. And I was wondering if there's been discussion around that component as to what that includes.
Well, it'll be up to the delegates to decide, but it is a broad brush, you're right. But it's basically, if I could summarize it this way, that is meant to say, who decides for you and I to be self-governing citizens? Is it going to be an unelected agency in DC, or is it going to be, the representatives that you elect to go to Congress? I think that, the power and jurisdiction of the federal government means that there's too much power delegated to unelected officials. And Dr. Ferris had mentioned earlier about the two main problems are the Commerce Clause and the General Welfare Clause. So just by tightening those two up, you have an ability to, to do, let's call it what it is, downsize the federal government. The federal government is bloated, out of control, spending wildly. And we suspect that some of these amendments that come out of there to basically have a better shot at having accountability to elected officials versus unelected agencies. Will come out of that limitation on government. So that's what we mean by limiting the power, scope, and jurisdiction.
Follow. Thank you, Mr. Chair. Again, with regard to, just your participation in this, last fall, state of Ohio voted on a constitutional amendment dealing with women's reproductive rights. And I'm again focused on the second agenda item, limiting the power and jurisdiction of the federal government. Could the topic of abortion be brought up in the convention where the delegates are considering either an amendment that would prohibit the federal government from allowing abortions, or saying that the federal government cannot prohibit abortions? Would that abortion topic be brought up in the convention, do you think, under this component?
Well, I'll take a quick shot at it, and I wanted to defer to the man who was behind the scenes in the Dobbs decision, has a lot of knowledge about what actually happened. But I would say that no, because it's not germane to those three topic areas. It's not having to do with the federal budgets, and not having to do with term limits, and it's not about an unelected bureaucracy running things in DC. So I would say no, it would not be germane.
To continue. Final. With regard to the operation of the organization, convention of the states, are there annual meetings or regular meetings of the state directors, and are those open to the public?
There are periodic, I wouldn't call them annual, I would say maybe biannual, every other year. We do get together as a group nationwide. The last one was in October, a year ago, October 22 in Orlando, and we had all 50 states represented there. We had primarily people like myself, state directors and state leaders. Our Ohio delegation probably had 8 or 10 people. It was not open to the public per se, because it was basically a meeting for training, for awards, for passing on information about our strategies and so forth. But there were members of, certain press, I think were there, not a lot, but somebody reported on it for the record. Okay.
Representative Hoops with the question.
Thank you, Mr. Chairman, and thank you. This has been very educational. My question goes back to the picking of the delegates. It's been mentioned that the legislature would be the body that would pick the delegates. What happens though, or could this happen, that there's groups out there that don't agree with that? Can these things end up in the courts? And I guess the second thing is, what courts would it be, the state court, or would it be the U.S. Supreme Court?
Well, that's a good question. I'm going to ask my colleague, Dr. Ferris, here to please tackle that one.
With your permission, Mr. Chairman, Representative Hoops, the last part of the question is the easiest to answer, and that is it's a federal constitutional question, and so it would end up in the federal courts, could end up in the Supreme Court of the United States, of course, and probably would on such a question. Can it be successfully challenged? You can file lawsuits about anything. I don't think there's a reasonable basis for challenging it, because I think the first line of defense any state attorney general defending it is this is in the political question doctrine. The courts routinely do not accept cases that they say are a political question. And so things like the way you select your delegates fall within the discretion of the elected legislature. And the courts don't have any judicially manageable standard to manage that by, so that there's no basis. It would just be substituting their wisdom for that of the legislatures, and they're going to kick this out in a heartbeat on political question. There are basically two lines of federal cases on, there's some state cases as well, but mostly federal cases on Article 5. There's a few that they get to, like, can you use the state constitution's initiative and referendum process in Article 5? The answer is no, and they've gotten to the merits of that multiple times, including cases from Ohio. But there are other questions, such as the one that you posed, that they kick out on the political question doctrine. So I don't think that litigation would get past first base, and they kick it out on a political question.
Representative Brown with the question.
Thank you, Chair. In your written testimony, you state this HJR 3 resolution is not about policy position. It is not about Republican or Democrat, conservative or liberal. Isn't it true, though, that the founders of the Convention of States project were Republicans, conservative Republicans, and that the primary funders of the Convention of States project are conservative Republicans and in some instances far-right folks?
I would say that the far right is a value judgment that I wouldn't necessarily say is true, but it's true that they are of a conservative nature. Dr. Ferris is one of the co-founders you just heard from, and Mark Meckler is also a conservative Republican. But I can tell you that this application, this process has broad bipartisan support. There have been many polls done across the country. In fact, just one about 2 weeks ago in the state of Pennsylvania, right next door, where the vast majority they did 800 voters of both parties, and 70% roughly of Republicans and almost as many Democrats supported the need for a convention of states. 65% of independents. So that it's pretty, it doesn't matter who runs the organization if its goals are understood by the people who support it. Would we love to have more people that are less on the conservative side? Of course, and we do have some. But that is what it is in terms of who our founders are.
Follow up.
Proceed.
Well, you mentioned Mark Meckler, one of the co-founders of the Convention of States. He's also the co-founder of the Tea Party Patriots, president of the Citizens for Self-Governance. There was an article June 23 in the New York Magazine entitled "The Dark Money Behind Mark Meckler's Convention of States," which traces the group's path and funding, and determined that the Convention of States drew in over $58 million in dark money between 16 and 21 from funds tied to the networks of the Koch brothers, as well as Leonard Leo, who are well-known right-wing benefactors of conservative and right-wing policies and interests. Also, according to SourceWatch, IRS filings revealed that the Convention of States action has donated to the following state Republican parties since 2020: Hawaii, Idaho, Kansas, Michigan, Texas, New Mexico, and Wisconsin, states dominated by Republicans. No money, however, has been donated by the Convention of States to any Democratic state parties. So there's no question to me that the Convention of States seems to have, both in its founding, its membership, its funding, and its primary support, folks who have pretty obvious far-right and conservative political leanings, and is heavily slanted toward one school of thought and one way of looking at issues. Isn't that fair to say?
Yeah, as I've said before, there's no denying that the organization was founded by conservative organizations. I can't really speak to that article. I haven't seen it. And dark money is one of those funny terms that people like to throw out there. And I can assure you that there's far many, if there is such thing as dark money coming in the organization, I'm not aware of it. There may be, I don't know. But the opponents have far more dark money, I would suspect. It's not unthinkable that they would have dark money as well. Dr. Ferris, do you have any financial comments on that?
Yeah, let's,
Okay.
are there other questions for this witness? Thank you very much.
Thank
Appreciate your testimony.
Thank you.
Next, we have Seth Wagman.
I'm going to cut my remarks very short, but I welcome
I believe the committee will be okay with that.
you to look at my written testimony and ask me any questions concerning anything that you find in there that's interesting to you. My name is Seth Wagman. Thank you, Chairman Peterson, Vice Chair Thomas, and Ranking Member Humphrey. I'm from Beaver Creek, Ohio, House District 70, and I will today discuss one of the pillars of the Convention of States movement, which is imposing fiscal restraints on the federal government. And I will do this by analogy. When a person seeks to get their finances under control, there's three things that they need to do. And I've been in this situation before. The first thing is to stop taking on new debt, unless it's an actual emergency. The second thing that you do is you pay off your debts to reduce the amount of interest that is flowing out of your budget. And the last step is then to get into a better situation where you are prepared for those emergencies and you don't need to go into debt ever again. Let's consider the federal government situation. There is a debt ceiling, but it is more fictional than real. It is a political football. The second thing, to pay off debts, there is no plan that I've ever seen where this federal government is ever planning to pay off its debts, much less get it under control. And saving for future emergencies, I want to bring that up. During World War II, the ratio of debt to GDP was lower than it is now. If we wanted to fight another world war, we would be in a very tough financial situation at this moment. I highly encourage you to allow this to go to the House floor for a vote. There have been surveys over nearly 40 years that on average, the people of the United States support a balanced budget amendment by high margins in the 70s. This can pass. This is realistic. And as Dr. Ferris mentioned, a single subject rule in combination with other amendments from the list of topics that are germane to the convention could present a realistic way forward for us to get the finances of the federal government under control. And one last thing to consider, the psalmist of the Bible stated, quote, "The wicked borroweth and payeth not again," close quote. That is, in my opinion, the way that the federal government is operating. We are printing currency and hoping that that is going to fool our debtors into believing that we plan to pay off our debts, but we have no plan. And it is up to us, the people in the states of this country, to bring this government under control. Thank you very much.
Thank you for your testimony. Certainly good advice that any financial planner would give to anybody. Are there questions for the witness? Thank you very much. Next up, we have Brenda Mitchell. Ms. Mitchell, thank you for joining us.
Thank you. Good morning, or good afternoon. Mic down, okay. Chairman Peterson, Vice Chair Thomas, and Ranking Member Humphrey, and members of the committee. My name is Brenda Mitchell, and I'm from Bellefontaine, Ohio, and I live in House District 85. Our system of electing members of Congress was intended by the founders to operate like a free market system, in the sense that legislators who served the people well could be reelected, while those who performed poorly would be voted out. The founders never intended legislators to make a career of Congress and to serve for 30 or 40 years, such as Chuck Schumer, Mitch McConnell, Nancy Pelosi, and Chuck Grassley. As proof, throughout the 1800s, the norm was for members of Congress to serve just 1 or 2 terms. From 1850 to 1898, turnover in Congress averaged 50.2%, meaning half of Congress was replaced every election cycle. Today, 9 out of every 10 members of Congress who run for re-election win. This might be reasonable if Congress were popular with the American people, but it's not. Congress's approval rating is about 15%. Clearly, our system is broken. And why is our system broken? Why can't the American people get the highly unpopular members of Congress replaced with new people bringing new ideas and to address our country's problems? The answer, in large part, is that incumbents have unfair advantages that bias elections in their favor. These advantages include incumbents have a 4-to-1 fundraising advantage over challengers. In many cases, the advantage is much higher. Incumbents can leverage political patronage, meaning politicians doing favors for constituents in exchange for votes. Party support usually favors incumbents, and incumbents usually have better established campaign infrastructure and staff compared to the challengers. Media attention usually favors incumbents, and access to government services, such as the ability to hold official events or town hall meetings, favors incumbents. Saying it simply, the deck is stacked in favor of incumbents. This is, for the most part, how Congress can have just a 15% approval rating and yet have a 90% reelection rate. The problems that have plagued our country for decades never seem to get fixed because the politicians who have either created them or have perpetuated them continue to stay in office. Problems like our national debt, immigration policy, our healthcare affordability, public school lackluster results, and the list goes on. One of the solutions to the problems is to place term limits on Congress. The 22nd Amendment to the Constitution places term limits on the presidency of the United States. It's now time for another amendment that limits the period of service for the U.S. Congress. Term limits for Congress would infuse the House and Senate with a regular influx of new people from the states with fresh ideas and solutions to our nation's biggest problems. It would decrease the concentration of power in Washington, D.C. by giving more citizens the chance to serve in Congress. It would help members of Congress to take their jobs more seriously, since they will be required to return home and live with the laws that they helped to pass or live with the problems they failed to solve while in Congress. It would also reduce the influence of special interest groups and lobbyists on politicians. I can imagine, as you're all sitting here, that there are members of the Ohio legislature who might aspire to serve in the U.S. Congress. A term limits amendment would only increase the opportunities to serve in Congress with more turnover in Washington, D.C. Some have expressed concern that term limits on Congress could backfire if the period of service is too short. This concern was reflected in the results of an Article 5 convention simulation that occurred last summer with actual state legislators. In that simulated convention, the proposed maximum length of service was set at 24 years. I think most would agree that 24 years of service in Congress is more than enough time to make meaningful contributions to our country. In closing, our country faces significant problems, and sending the same politicians back to Washington, D.C. every election cycle is not working. Placing term limits on Congress through an amendment to the Constitution will help improve that situation. Term limits on Congress is very popular with the American people. A recent poll found that 80% of Americans support it. Term limits would increase the opportunity for more Ohioans to serve in Congress, including members from the Ohio legislature. For these reasons, please support passage of HJR 3. Thank you. Do you have any questions?
Ms. Mitchell, thank you for your testimony. Are there any questions? All right, well, thank you.
Thank you.
Is Ed Mulholland, we call Ed Mulholland next? Thank you.
Vice Chair Thomas, Ranking Member Humphrey, members of the committee. My name is Ed Mulholland. I'm from Zanesville, Ohio, House District 97. I'm a volunteer with Convention of States Action, and we seek your support of HJR 3 to address runaway overreach of the federal government. The Declaration of Independence was an announcement to the world that the colonists could and would manage their own affairs. It was a statement establishing the right of individual liberty and local sovereignty. The Constitution followed, securing the liberty of the people while granting the federal government only 27 enumerated powers. Later, the Bill of Rights reinforced, the 10th Amendment reinforced the limits on federal power. James Madison, an author of the Constitution and fourth President of the United States, put it this way: the powers delegated by the Constitution to the federal government are few and defined. Those of state governments are numerous and indefinite. By dividing power between the federal and state governments, the framers built a safeguard into our political system to restrain federal overreach. This division of power is called federalism, and sadly, it's been dying a slow death for decades. The death of federalism has led to a concentration of power at the federal level. As the power of the federal government expands, so expands the necessary regulation and control that steals the very liberties the government is supposed to protect. Why is federalism on its deathbed? Prior to the New Deal era, local economic activities such as labor, manufacturing, agriculture, mining were widely understood to be under the purview of state governments. They were not considered part of interstate commerce. Then, Supreme Court decisions like upholding the National Labor Relations Act in 1937 and Wickard v. Filburn in 1942 dramatically changed the interpretation of the Constitution's Commerce Clause, enlarging the federal government's lawmaking authority at the expense of state sovereignty. With its new expanded authority, the government grew so much, Congress was forced to defer a great deal of authority to newly created agencies, and today the number of statutes passed by our elected representatives in Congress is dwarfed by the number of regulations created by federal agencies staffed by unelected bureaucrats. The Supreme Court's arbitrary reinterpretation of the Commerce Clause can be corrected with an amendment to the Constitution. Doing so will rightly shift power out of Washington, D.C. and back to the states where it belongs and where our country's founders intended it to be. This will help revive federalism and the balanced power between federal and state governments. Another contributor to the death of federalism was the United States v. Butler decision, heard about a little bit earlier, which reinterpreted the General Welfare Clause. Prior to this ruling, the General Welfare Clause was interpreted to mean that Congress could only spend money in service of its 27 enumerated powers. It could not spend money on activities states could spend money on. For example, states can spend money on education, welfare, medical, and retirement programs. Accordingly, Congress had no jurisdiction for such programs. However, after this Supreme Court ruling, the floodgates were opened and Congress was permitted to spend money on essentially anything it wanted. This Supreme Court reinterpretation of General Welfare Clause can also be corrected through an amendment to the Constitution that clarifies the clause according to the framers' intentions. Pandora's box of federal government expansion can, in fact, be closed with such an amendment. Now, some of you might be wondering, what would happen to federal programs Americans have come to rely upon, like Social Security? Those programs don't have to end. Their administration could shift from federal government to state governments. The programs could be more closely tailored to the particular needs of each state. As our elected officials, you would be in control. And we all know states tend to be more efficient with their resources and more responsive to their citizens' needs. In summary, federalism is all but dead in our country due to an ever-expanding federal government that treats states as federal agencies. This is a dangerous slide toward the concentration of absolute power at the federal level, concentrated power that always leads to tyranny and loss of individual liberty. This imbalance of power is a result of Supreme Court decisions that reinterpreted the Constitution, taking power from states and giving it to the federal government. To preserve state sovereignty and the liberties of the people, we must restore federalism. HCR 3 calls for a convention and gives states the opportunity to at least discuss this important issue. I urge you to support HJR 3.
Thank you for your testimony. Are there questions for the witness? Representative Brown.
Thank you, Chair. Thank you, sir, for your testimony. In your written remarks, you indicate that the Article 5 convention will be called for the purpose of proposing amendments to address the, quote, threatening overreach of the federal government, quote. What you see as the threatening overreach of the government, millions and millions of other patriotic Americans see as the appropriate exercise of federal power. Do you understand that we have this divergent point of view in America?
I do understand, but I think that we don't necessarily disagree on the things that should be accomplished. We disagree on who should be implementing those things. So these things that are happening at the federal level are things that we could be dealing with locally. Ohio ought to be able to decide for itself how to do, any number of things that the federal government has taken from it. We had 13 independent sovereign states come together and agree to have this federal government over it to manage some things that they needed managed between themselves. They didn't voluntarily give up all their sovereignty and just say, okay, we're just going to administer whatever you tell us to do. So, again, Social Security, welfare programs, all of those things can be handled locally. And by the way, I would argue that the money spent would be spent more efficiently. We already know, like, if you look at community block grants, up to like 70% when you count how much administration the federal government's allowed to charge, how much administration the state governments are allowed to charge, and how much administration the local government can take off the top of a community grant. And then the amount of administration the person actually implementing the program can take, up to 70% of the dollars go to administration. If we could cut out the Fed, we might get to 50% actually getting down to doing what we want done.
Follow up, Chair.
Continue.
I'm sure you're aware, because you seem like a very intelligent, informed individual, that this debate about states' rights, state power versus the federal power is the debate as old as the nation itself, that even before the Constitution was enacted, the Federalist Papers, prepared by a number of different of the founding fathers, including Hamilton and Madison, debated vigorously the role of the federal government versus the state government, the power and influence of the federal versus state government. And you mentioned in your comment, in your testimony, we need to go back to the framers' intention. And I believe that a close examination of the actual historical record demonstrates that the framers' intention is always very difficult to ascertain, because different framers had different views, different intentions, different purposes, and different ideas about the best way to go. And they fought vigorously on these things. And so I assume you're aware of that historical antecedent, correct?
And I think we should, to the chairman and to Representative Brown, I'd love to see us have that conversation again and confirm where exactly we think this country should be headed. And an Article 5 convention gives a chance for legislators like yourself to send delegates and have a conversation. And then, of course, when we send these proposed amendments, if any get a majority vote at the convention, out to the states, there'll be a huge national discussion about all these issues.
Final comment, if I may. Thank you, Chair. I appreciate that. I do. but it seems to me that this debate has been going on since prior to 1787, and it's still going on. I'm not sure the convention that you refer to would be the panacea that you believe it to be, so I'm not so sure I agree with that. But I appreciate your position, and you're certainly you're right to espouse those positions, and I thank you for your testimony. Thank you.
Seeing no
Thank you.
further questions, our next presenter would be Roger Gibbs. Mr. Gibbs, thank you for being with us today. Appreciate your patience.
It's my pleasure. Thank you, sir. Yeah, so my name today is, Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. My name is Roger Gibb. I'm from Mason, Ohio, House District 56. So in 2022, the Trafalgar Group conducted a nationally representative survey of American adults. What they found is that 66% of Americans supported an Article 5 convention for proposing amendments to rein in the federal government. Even so, we know that there are people on both sides of the aisle who are opposed to what we're doing. And some of them are under the impression that a convention of states would be dangerous. This fear stems from opposition claims that states can't be trusted to amend the Constitution. They contend that states might try to entirely replace the Constitution or scrap some or all of the Bill of Rights. Now, to put this in perspective, let's just imagine that you go skydiving with a friend, okay? You both get up into the airplane, you jump out together, and after free falling for a couple of minutes, you realize it's time to release your parachutes. So you reach back and you both pull that strap, but nothing happens. Parachutes don't deploy. You both panic for a minute and then you remember your training. You've got a second parachute in your backpack. So you reach back to deploy that second parachute, but your friend screams at you, don't deploy it, it's too dangerous. Confused, you look down at the ground, it's coming up very fast. You look back at your friend, and you say, the second chute is there in case the first chute doesn't work. It's for our safety, do you have a better idea? Your friend looks back and says, no, but don't do it, it's too dangerous. Now, I know that sounds absurd, but that is pretty much what our opposition says about this effort. We, the American people, we're the parachutists, and we're faced with a very dangerous situation. Our federal government is literally bankrupting our country, among other things. And Congress is the first parachute. And if Congress were listening to we, the people, they would propose reasonable amendments like a balanced budget amendment. But Congress refuses because Congress is part of the problem. Now, our second parachute is for states to propose amendments. Yet our opponents say, no, that's too dangerous. Do they have a viable alternative? No, but they're insistent on stopping us from deploying our proverbial second parachute. Now, we know from previous experience that in upcoming committee hearings, you're going to hear claims from our opposition that proposing amendments to the Constitution via Article 5 is too dangerous. At the end of the day, you're all going to have to decide what to do with that. Convention of States and the people who are testifying before you here today, we rely on a team of nationally acclaimed attorneys to help ascertain and confirm the safety of the Article 5 process. Two of our most prominent attorneys are Michael Ferris, whom you've heard from today, and Robert Nadelson. Since you already have met Dr. Ferris, I will tell you about Robert Nadelson. So he is a law professor of 25 years. His research has been cited repeatedly at the U.S. Supreme Court, federal appeals courts, and state Supreme Courts. He's widely acknowledged to be the nation's preeminent scholar on the Article 5 process, having written the only legal treatise on this subject. So I hold his book in my hand, The Law of Article 5. He is the author of no fewer than 40 articles on the Constitution in peer-reviewed legal journals. 5 of those articles were published just in the past 13 years, specifically on the Constitution amending process. Now, collectively, Michael Ferris and Robert Nadelson have written more than 300 pages. Okay, I have them printed here, front and back, 300 pages in legal journals over the past 13 years to specifically debunk claims from our opposition that somehow following the legal lawful process of Article 5 is too dangerous. Now, because these writings were peer-reviewed, they were rigorously evaluated by other constitutional experts for historical accuracy, 2 centuries of Article 5 usage, and a long line of Article 5 court decisions extending from 1798 to the present century. And so in conclusion, when you hear and read opposition testimony in the upcoming committee hearings, we urge you to evaluate their claims that following Article 5 of the Constitution is dangerous against the following 2 criteria. First criteria, are their claims simply statements of opinion, or have they been vetted by real constitutional experts through the peer review publication process of legal journals like the writings of Michael Ferris and Robert Nadelson? Criteria number 2, are their sources contemporary, meaning are they from this century? Put more simply, is their material outdated? This is important because our opposition likes to cite sources from the 1950s, 60s, and 70s, when activist judges and professors favoring big government made unfounded claims to stop states from amending the Constitution. If so, these claims have very likely been debunked by the 21st century scholarly writings of Michael Ferris and Robert Nadelson. So putting it simply, if our opposition can't get their provocative claims peer-reviewed by real constitutional experts and published in reputable law review journals, then I would submit to you that they're not credible and you shouldn't take them seriously. If you hold our opposition to these high standards, what you're going to find is that very few, if any, of their claims are worthy of your serious consideration. Thank you.
Thank you for your testimony. Are there questions for the witness? I have maybe one.
Yeah.
I've heard the argument before that, we don't really have to worry about a convention of states because as we get towards 33 states, 32 states approving, that will get the attention of Congress or leadership that something will happen.
Yes.
What's your thought on that, if you don't mind
Well,
sharing?
I'm not an attorney, but I think it is very likely because I don't think Congress wants to lose complete control of things. And so if we get to 33 states, maybe Congress will find religion of financial responsibility and decide to impose or propose its own balanced budget amendment or some other reasonable thing. So I think it is quite possible, but that's just me. Yeah.
Thank you. Thank you for your testimony. So next we have Michael Maury. Mr. Maury, thank you for joining us today.
Thank you for having me. Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. My name is Mike Maury. I'm from Ashland, Ohio, House District 67. My remarks today are intended to refute the false claim by many that oppose the call for an Article 5 convention that the Constitutional Convention of 1787 was a runaway convention. Some opponents make claim that an Article 5 convention held today would run away like the last Article 5 convention. This is wrong in 2 regards. First, there has never been an Article 5 convention for proposing amendments. The Constitutional Convention of 1787 was not convened under the auspices of the Articles of Confederation. The word convention does not even appear in the Articles of Confederation. An Article 5 convention, however, is prescribed and structured in our current U.S. Constitution. Second, the authority to propose our Constitution to Convention of 1787 was largely within the scope of the broad commissions granted by most state legislatures to their commissioners. The demise of the Confederation was widely expected, even welcomed by many prior to the convention. These included members of the Confederation Congress when Congress recommended that a convention be held. See Congress's resolution and Madison's journal entry that day in the attached summary. The time allotted for this testimony, which is an analysis of 12 years of history, does not allow for anything other than a short verbal outline of the topic. So I've attached to this written testimony a summary with hyperlinks to the source material. Included with the attachments are scholarly peer-reviewed articles by Dr. Michael Ferris and Professor Robert Nadelson, which you heard reference to earlier. Dr. Ferris's article is regarding the Convention of 1787, and Professor Nadelson's is regarding conventions of the founding era. You'll also find in the attachments full copies of the calls to the convention by each of the states that sent commissioners to the convention, as well as a copy of the Articles of Confederation.
It's important for any review of why the Confederation was failing and why there was a desperate need for reform to understand the context of why many, if not most, of the participants in the political system of the day deemed that reform was needed, but not possible within the limitations that constrained the Confederation Congress. This context is important as an assertion is often made that a convention for proposing amendments cannot be safely held in our current times of turmoil as it was during the calm times after the war when the Convention of 1787 was conducted. This assertion is faulty in two regards. First, it can be noted that the Convention Clause of Article 5 in our current Constitution was specifically included with expectation it would be utilized during difficult times when an intransigent national government resisted the will of the people. Second, the Convention of 1787 was conducted during anything but calm times. The states in the Confederacy were far from untroubled. These troubles spanned from the early days of the Confederation in June of 1783, when Congress was chased out of Philadelphia by segments of their own army, right up to the tax rebellions culminating in the infamous and deadly Shays Rebellion, where rebelling farmers and veterans received volleys of grape shot from the cannon of hired militia just months prior to the convention. Attempts to reform the Articles of Confederation were attempted as late as August of 1786, after the Annapolis Convention, with 7 amendments proposed by Charles Dickinson. A vote on these proposed amendments was not even taken due to the belief that they could not be passed. It is in the context of this environment that 12 of the states recognized the need to call on the Confederation Congress to recommend that a convention be held to reform the structure of the national government. Points refuting the myth of the runaway. The Convention of 1787 was not a runaway convention. This suggestion is a slander on our founding fathers, the implication they were either incompetent or duplicitous in the conduct and outcome of the convention. The Convention of 1787 was not constrained by the Articles of Confederation, which was in part the point for calling the convention, to effect reforms that could not be achieved by Congress. The original suggestion of the Grand Convention of 1787 was made by delegates at the Annapolis Convention of 1786 in recognition that broad powers outside the means of Congress were needed to cure the defects of their present frame of government. The Annapolis resolution proposed that among the powers granted, the commissioners of the subsequent convention would be discussing all such alterations and further provisions as being necessary to render the federal Constitution adequate to the exigencies of the Union. The Convention of 1787 was not a runaway. This is evidenced by the broad language of the resolutions by at least 10 of the 12 state legislatures. Excerpts and complete copies of these can be found in the attachments to this testimony. 10 of the state resolutions largely copied the broad scope suggested by the Annapolis resolution. Contemporaneous correspondence, which is included in the attachments of political leaders and participants prior to the start of the convention in May 25th of 1787, clearly show it was expected that the commissioners at the convention would have broad powers. A sampling of their correspondence, which is included in the attachments prior to the commencement of the convention, are things such as Madison to Jefferson in August of 1786. Many gentlemen, both within and without Congress, wished to make this meeting subservient to a plenipotentiary convention for amending the Confederation. Madison to Jefferson, December 4th, from the Virginia State Legislature. The recommendation for the meeting at Annapolis of a plenipotentiary convention in Philadelphia in May next has been well received in the assembly here. I won't read the rest of the citations. You can read those in your attachments. The Virginians, who were the first state to make a call to convention, clearly expected the commissioners to have broad powers to replace the Articles of Confederation. They basically showed up, and on the second or third day of the convention, they already had the Virginia plan in place, and Charles Pinckney of South Carolina also had the Pinckney plan, both of which were strong nationalist plans that could only replace the Articles of Confederation. The outline of the Virginia plan was fully laid out to George Washington in a letter from Madison on April 16th, a month prior to the convention. In closing, I'd say it can be observed in most of the records of the state ratifying conventions, the general sense was not the commissioners did not exceeded their authority and was not a runaway convention. The framers delivered the possibility of a needed reform that was not attainable by other means. While there were minor amounts of grousing by some anti-federalists about the commissioners exceeding their authority, it was recognized by most people that what Washington described as temporizing application would have been adequate to prevent the disintegration of the Federation and allow the means to integrate the states into a lasting republic. This acceptance, I think, was not just because of the needed elimination of the inadequacies of the Articles as a functioning central government, stipulation that ratification be by the people within the states, making it truly a constitution of we the people. More detail in the source material and with hyperlinks to the source material available to you in the attachments.
Thank you for your testimony. I will say, Mr. Maury, that you worried me a little bit when I saw 263 pages.
These are mostly,
But flipping,
these are mostly Dr. Ferris's fault.
yeah, flipping through the attachments, I will try and read those. Those are pretty interesting stuff. So I encourage everybody to read that at some point.
A lot of data. If your hyperlinks don't work, let me know if they got stripped away.
Yeah, it's really good stuff. Are there questions for the witness? Thank you.
Thank you.
Next, we have Paul Cisk. Thank you, sir, for joining us.
Thank you. Chairman Peterson, Vice Chairman Thomas, and Ranking Member Humphrey, members of the committee. I am Paul Cisk. I come from Hamilton Township, Warren County, Ohio, District 55. I want to begin with a quote. If you're reading, it's not in my material. I think you need something fresh. It appears that I could not do your job sitting all day listening, and how you do it, I want to commend you. I don't know how you can absorb it all and hold it all in. I think your posterior is probably speaking to you.
We have padded seats. You and the audience do not, so sorry about that.
A nice luxury. Blanchard said, whenever you're making a presentation, state the issue simply, handle objections fairly, drive a strong conclusion. Most of the things that are in my testimony have been covered. So I'm not going to spend time reading it to you. I know you say thank you very much. But I do want to convey to you, as you should see from these people who have given up their days of work, as I've taken a day off of work, and the hours that have been spent in preparation and rehearsal for this day. To me, this is not about labels. This is about patriotism and country and doing the right thing. This is why my vote counts, and this is why I'm here today. My specific remarks are intended to dispel the claim that a Article 5 Convention of States would create a runaway convention. And things from that would result in a loss of Bill of Rights or, in fact, our entire Constitution. And of course, you've already heard comments about that. My sources are the same, Dr. Ferris, Dr. Nicholson. An Article 5 convention for amending the Constitution is just simply about 50 states getting together, convening a meeting, and talking about ways that we can make America better. Amendments. This is how we're supposed to do it. Multi-state meetings and conventions have been going on for years. In fact, more than 350 years. And in the 40 multi-state conventions that we have on record in America, none have resulted in a runaway convention. Not one, not even a hint of one, zero. In the case of Article 5 conventions, there are 9 safeguards to ensure that we are meeting the intentions of the framers of the Constitution. I'm just going to hit them briefly. First order of business is to elect the right leaders. It's up to you. That's why we elected you. You choose the leaders. We're counting on you. Do the best you can. You choose how it works. We're counting on you. Safeguard number 2. Opposition claims that delegates will have plenipotentiary, that is, unlimited power of the convention. And that's not true. They only have the power that you give them. If you give them the power, then you are responsible for what they're going to do. So the onus is on you. Number 3. Well, let me go back to it because I think this is important to state. This HRJ 3 states that a convention of states for proposing amendments to the Constitution of the United States convened pursuant to this application shall be limited to consideration of the topics herein specified and no other. So whatever you choose, right, your delegates are going to only be able to talk about that thing. And my safeguard number 3 is there's no provision in the Constitution for replacing the Constitution. It's ridiculous. Number 4, in order for an amendment to become officially proposed at a convention, 26 states have to vote for it. And since 34 plus states will have requested the convention, then there's no way an amendment for rescinding any component, for example, of the Bill of Rights. That could not happen. 26 states getting together, you know there's no way that that could happen. The 34 plus states that requested the convention would never vote for it. Number 5, if by some means an amendment was proposed that fell outside of the scope of the convention and what your delegates are supposed to be doing, Congress would be obligated to select a mode of ratification, and then the process would stop. It would kill any invalid proposal. Number 6, the Constitution stipulates that after an amendment is officially proposed at an Article 5 convention, it only becomes part of the Constitution if it's ratified by 38 states. We've already heard this argument. Number 7, if a delegate were to violate their duty or their instructions, they can be recalled. And in HJR 3, it states the Ohio General Assembly may provide further instructions to its delegates and may recall its delegates at any time for a breach of duty or for a violation of the instructions provided, end quote. It's there. Number 8, in many states, their resolutions requesting an Article 5 have explicit limitations on the delegate's authority. And because this is in the resolution, I'm going to read it. Quote, the application is made with the express understanding that an amendment that in any way seeks to amend, modify, or repeal any provision of the Bill of Rights shall not be authorized for consideration at any stage. This application shall be void ab initio if ever used at any stage to consider any change to the provision of the Bill of Rights, end quote. And the last safeguard is that states can pass statutes pertaining to Article 5 convention delegates faithfully following those instructions. For example, Indiana has passed legislation with this provision, quote, a delegate or alternate delegate who knowingly or intentionally votes or attempts to vote outside the scope of the instructions established or the limits placed by the General Assembly commits a level 6 felony. America has a rich history of multi-state conventions, more than 40, over 350 years, never had a single case of a runaway convention, not one, ever. And I've given you some safeguards here to ensure that an Article 5 convention complies with the Constitution. I have to tell you that we are all concerned, and you are too. You're an American. You're an Ohioan. You read the papers, you hear the news. We're all concerned about our future. I got 4 little grandbabies. I'm concerned about their future. I want them to grow up in the kind of America that we have grown up in, to enjoy the same benefits and privileges. And if we don't pull back on some of the things that are out of our control at the moment, we're not going to see that become a reality. I think it is time that we exercise our constitutional rights to restore justice, discipline, and order to our republic. And I'm asking you to help us by supporting HJR 3. And I am grateful for your service. Thank you.
Thank you for your testimony. I'll probably say this again as we wrap up, but having led some of these discussions in past and in the Senate, I have yet to have somebody come present that I didn't think loved their country as much as their family. And that's true of all of you here today, and thank you for that. Representative Graham.
Thank you, Mr. Chair. Thank you so much for coming today and speaking on this. So I wanted to go back to your safeguard number 7,
Okay.
which is the Ohio General Assembly may provide further instructions and may recall its delegates at any time for a breach of duty. So I know that kind of the point of the convention is that the feeling around that states don't have the rights that they used to have, but there is a checks and balances in our government around states and federal government, and then we go to the court. So where is that checks and balances around if a delegation is doing the right thing or the delegation is maybe breaching their duty, where does that fall in that checks and balances?
Well, I think in this case, if the Ohio delegation does not follow the instructions that have been given to them by the legislature, then the legislature has the power to pull them back. Now, another consideration too is the example was given in New York when Alexander Hamilton, he had to follow the instructions that were given, and it took all three making the vote. Two left. He was left with no other choice but to participate and yet withhold his vote. So I think the responsibility lies with the legislature, which is where it belongs to begin with. This is part of bringing the power back to the state. And while we're on that point, I would also suggest too that, as was referenced before, the federal government and the state government, it's a balance. But the problem is that we have balance issues. We have to balance our budget. The federal government does not. And if we don't take back this control, then the federal government will continue to go down this same rat hole.
Follow.
So the legislature, so us, we provide that, but then if we're saying someone says we're misstepping, it's the courts, right? So is that checks and balances going with the court? So say some of the delegation says we're fine, we didn't do anything wrong. Like, does that go to the courts then as that checks and balance?
You know the answer. Okay. That's beyond my knowledge, so I'm going to pass on that to let Dr. Ferris answer it.
Continue.
To the
Next
chair, yeah, from the chair, could we get that information? How would that check? Yeah, thank you.
If you share that with the chairman, I'll make sure everybody in the committee gets to see that.
Certainly will.
Also.
Thank you. Thank you for your
Representative
question.
Brown with a question.
Thank you, Chair. Thank you, sir, for your testimony. Appreciate it. You stated that those folks who are here today in support of HGR 3 are filled with patriotism and love of country, and I have absolutely no reason to disagree with that or think that isn't true. I know it is.
Sure.
Do you understand, though, that folks who may disagree with the HGR 3, who do not think it's a good idea, they also are patriotic Americans who also love their country and also want what's best for their I have 5 grandchildren. Do you understand that, sir?
I do indeed, and I respect that they also can share the same feeling of patriotism and country, love of country. They can also share the same love of other things, love of God, love of participation, love of education. I think what happens here is that we're providing a mechanism for all of us to share together by putting together a bipartisan group of delegates who get together and they talk about it, the legislature talks about it, and then we as all the states come together. So I don't sense that this is a partisan issue. I think that really everybody desires to have these basic 3 things. And we may have some fine tuning of some of the wording, but the basic 3 principles, I think, apply with everyone. I may be wrong.
Continue.
Follow up. Thank you, Chair. You talk about giving power to the legislature to kind of oversee how this works so that it works well. And I just want you to understand and take this into consideration. The legislature you're talking about, the Ohio legislature, is a result of gerrymandered districts. We have 67 Republicans, 32 Democrats, which do not reflect the percentage of R's and D's in the state. And there were 5 Supreme Court decisions of a Republican-dominated Supreme Court with a Republican Chief Justice, don't say I'm wrong, I'm right, who said that this was unconstitutional on 5 occasions. 5 occasions. So what you have is a gerrymandered legislature that does not represent the people in defiance of the Ohio Supreme Court. And that's the body that you are entrusting to do the right thing, and I just have concerns about that.
And I appreciate your concern. I can tell you that I'm left with what I have. This is the mechanism that I have. If there were a way to, run the magic wand over, we could do it differently. But if there is another mechanism, then let's look at it. But in this case, I have to go back to the fact that these are common principles. I can't see where any of this is going to be detrimental to anyone, regardless of your label or stripe or background or ethnicity or any other political issue. I think we all share the same desire to have a better future.
Other questions for the witness? Thank you for being with us today.
Thank you, Mr. Chairman.
Next, we have Chad Gump with testimony. Mr. Gump, thanks for your patience today.
Thank you. Thank you. Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. My name is Chad Gump, and I'm from House District 49 in North Canton, Ohio. Today, my remarks are to refute two of the common claims that are made by some people that do oppose a convention of states, and appreciate everyone's time here today, and I've been asked to try to get the things out of there that we've already discussed. I'll do the best I can on that, okay? The first claim that you might not have thought about is that somebody said, well, there's absolutely no rules in the Constitution for how to run an Article 5 convention. So it's a good question, and then the question becomes, well, it could go anywhere without any rules. So reverting back to that Professor Nadelson that you heard him talk about a little bit earlier, he explains the Marquette Law Review in an article from 2020. And I want to quote, say it exactly the way he said it, so I'll try to keep it moving, okay? He said, competent constitutional scholars do not assume a phrase has no meaning merely because the Constitution and the framers' records do not define it. The usual reason for the lack of definition is the term is so well known and understood that there's no need to explain it. Things like illustrated phrases like original jurisdiction or trial by jury, those weren't originally explained out well either, but they were well known. So really, for that reason, the founders didn't really put a lot of time into not wasting space, but taking space out of the Constitution. The other thing that I found very interesting is that there were 11 multi-state constitutions already in process or completed just after the signing of the declarations. And so we already had a background on what the rules would be. And some of those we already talked about. I'm going to hit on it real quick. We already talked about the state legislators are going to select who's going to be involved in it. We kind of talked about that a little bit. We talked about the voting. And I do want to click on one thing at the end was if the majority of states did not endorse a particular solution, it just wasn't adopted. It wasn't proposed. So if, kind of maybe explains itself, but I wanted you to know that. So there really isn't any claim that there are no rules for an Article 5 convention. Another claim would be the fact that since Congress calls the convention, well, why don't they just take it over and run it in the ground or do whatever they want? But he explained also in that it had been very clearly through multi-state conventions seen before that they could determine the time and the place and the purpose, but that's as far as they could go. So that was what they were, that's what their responsibility was. And he further clarifies that the overriding purpose of the state application and convention procedure is to bypass Congress. So if Congress could structure the convention, this would largely defeat the overriding purpose, which makes sense. Originally, if Congress were to dictate the state legislators how to select commissioners, then the Congress would be invading the incidental authority of the states as well. So it's kind of shown that time, place, and subject matter is their place in it. So without that, there really isn't a claim that they would override the power of a convention. So I try to pick and choose what you guys maybe hadn't already heard. So thank you for everything. Thank you for your time. Does anybody have any questions for myself or possibly someone in my group?
Other questions
that
for
could
the
answer
witness?
better?
Thank you for your testimony. We
Thank you.
appreciate it.
Thank you.
And we appreciate summarizing at this point in the day. Next, we have John Laws. Mr. Laws. Thank you for being with us.
Thank you, and I will summarize as well. Chairman Peterson, Vice Chairman Thomas, Ranking Member Humphrey, members of the committee, my name is John Laws. Yes, it really is, L-A-W-S. I'm from South Lebanon, Ohio, House District 56. since there's been some lively discussion on we as Ohioans, I will throw in that I'm a graduate of Ohio High School. I'm also a double graduate of Ohio Public University. So I've been around a while. I'm going to skip through a few things here. So if you're following along on your iPads, I may skip a few paragraphs. But today I was going to discuss an opposition statement that we often get about amending the Constitution will provide no benefit because the federal government does not follow the Constitution now anyway. Well, I can appreciate the federal government doesn't follow the Constitution now, and I know I've expressed that sentiment myself on several occasions. While I am not a constitutional attorney nor a constitutional scholar, I've learned that to comprehend the subject, one must first recognize that the federal government is not required to follow the original Constitution as written by our founders. Rather, it's required to follow the Constitution as interpreted by the Supreme Court of the United States. That's a major difference. The improper accumulation of power by the federal government and the departure from the following Constitution as originated by our framers has risen in a sense from the Constitution itself. The Constitution permits the federal judiciary to be the final arbiter, interpreter of the Constitution. Because the framers did not have a great deal of experience in the practice of judicial review, they did not assign adequate checks and balances on the judiciary's branch of government, did not foresee how the Supreme Court would legislate from the bench. So once you understand this, it becomes clear how the federal government can justify some of its actions. The Constitution as interpreted by the Supreme Court today is the problem. This interpretation allows the federal government to engage in undeclared wars, provide government agencies with the capability to spy on us, the US citizens, you, massive federal debt and devaluation of our currency. I think we've all lived through a lot of that in the last 2 years. Executive agreements with foreign powers without Senate ratification, which is a direct violation of the US Constitution, and the deregulation of rulemaking to unelected bureaucrats. We've had that discussion on many topics by my compatriots here today. I'm going to skip the next 3 or 4 paragraphs and go to the summary, because again, you have a cushion and I don't, and I'm getting a little tired. So, in conclusion, the claim that amending the Constitution would provide no benefit because the federal government doesn't abide with the Constitution anyway is a bit misleading because it naively overlooks the fact that it's not the original Constitution. It's the one approved, authorized, and promoted by the Supreme Court. Through changes to the existing Constitution using an Article 5 convention, we can resolve most of this, or at least improve our lot in life and where we are with everything that we live and do. So it could return us to a separation of powers that's more acceptable. It could return us to a closer to the federalism that our country was originally founded on. And I would add, in doing this research and talking to many people, I probably knocked on 500 doors last year. Republicans, Democrats, non-committed. And at least 80% of those doors I knocked on approved of the 3 principles we're presenting to you today, Article 5. And we had many lively conversations about all the things that are going on. And I heard some of those exact feelings expressed from those folks out in the field too, on both sides of the aisle. So we need to do something. We need to move forward as a country. And we do have a huge divide in front of us. And a person mentioned that today. Let's try to build a bridge across that divide. Let's use the Article 5 process to get that done, to make progress, to push this forward. Because if we continue to ignore the ability that we're given in the Constitution to make that attempt, we're not going to go any further than we are today. Thank you for having me. I'll answer questions as I might be able.
Other questions from the witness? Representative Brown.
Thank you. Thank you for your testimony, sir. You're talking about the role of the Supreme Court in interpreting the Constitution, the constitutional provisions, and your assessment. I take it that the court has exceeded its proper scope and authority and legislated from the bench. You say you're not a lawyer. I've been a lawyer 42 years, and my observation is that if someone agrees with a Supreme Court decision, they tend to believe that the court made a rational, reasoned decision based upon the facts and the law, and that their decision was well within their scope and authority and purview. But if they disagree with the decision, they tend to say that the court was legislating from the bench. And have you experienced that as well, or am I looking at it from not your vantage point?
I probably actually see it more as you see it from, again, not being an attorney. I spent very little time of my life, in fact, almost no time of my life in a court. So I have can't pull an immediate, sort of one-to-one to that. My observation is in the reading and study that I've done, this is sort of a process of death by a thousand cuts. It started back in the 1804, 1810 era, and just little nicks and cuts all the way through. It really accelerated under FDR, and there are probably 24 different decisions that were made that really went against the General Welfare Clause in particular, and the Commerce Clause. And then that sort of has continued through where we are today. Were some of those things necessary? Absolutely. Were some of those things good for the general welfare? Absolutely. Some of the reverse may be as well true. So that's my opinion as a citizen of this state and this country. Again, I'm not an attorney. I chose not to spend time in courts and instead invested my career in technology and making sure you had things like you have today to follow me along when I'm talking.
Thank you for your testimony. Appreciate you being with us. Next, we have Susan Dunn. Ms. Dunn. Thank you for sticking with us today.
Of course. Chairman Peterson, Vice Chair Thomas, Ranking Member Humphreys, and members of the committee. I am Susan K. Dunn from Westchester, Ohio, House District 45. I am a supporter of Convention of States and HJR 3. One of the frustrating things that I have experienced in my time with Convention of States is how opposition has stood up in hearings like this one and used only partial quotes to mislead the committee. Today, I want to address one of the false claims that they have made before and will probably make again. It is the claim that the late Supreme Court Justice Antonin Scalia was opposed to Article 5 conventions. To achieve their objective, our opposition has cherry-picked a statement from Antonin Scalia while ignoring other statements that he made. During an interview with the Kolb Report in 2014, Justice Scalia was asked the question, if you could amend the Constitution in one way, what would it be and why? He responded saying, quote, I certainly would not want a constitutional convention. I mean, whoa, who knows what would come out of that? Then Scalia continued to speak, yet opposition ends their quotation of his comments right there. They want you to believe that when Antonin Scalia said he would not want a constitutional convention, that he was referring to an Article 5 convention for proposing amendments. At first blush, it's not clear what he meant when he said constitutional convention. Was he referring to an Article 5 convention for proposing amendments, or a constitutional convention for writing a whole new constitution like the one held in Philadelphia in 1787? Perhaps we can gain a clue from the rest of his statement. Here is his entire statement. quote, I certainly would not want a constitutional convention. I mean, whoa, who knows what would come out of that? But if there were a targeted amendment that were adopted by the states, I think the only provision I would amend is the amendment provision. I figured out at one time what percentage of the populace could prevent an amendment to the Constitution, and if you take a bare majority of the smallest states by population, I think something less than 2% of the people could prevent a constitutional amendment. It ought to be hard, but it shouldn't be that hard, unquote. The full quotation makes it clear that Antonin Scalia supported amending the Constitution. In fact, he thought it should be easier to amend the Constitution by the states. This paints a very different picture. This suggests that when he was opposed to a constitutional convention, he was actually referring to a convention like the one in Philadelphia in 1787, not an Article 5 convention. Please note that our opposition will use the term con-con when they're actually referring to an Article 5 convention for proposing amendments. There have only been 2 constitutional conventions in U.S. history, the one in 1787 and one in 1861 for the Confederate Constitution. Our opposition's use of con-con causes confusion and reinforces the mental image or fear of a junta, not merely to propose some amendments, but would rewrite the entire Constitution. Don't be fooled. This is intentionally and totally misleading. For additional clarity on Antonin Scalia's true opinion, we can look to a 1979 panel in which he participated. This was at the time of the balanced budget amendment drive. Regarding Article 5 convention specifically, he said, quote, the Congress is simply unwilling to give attention to many issues which it knows the people are concerned with, which issues involve restrictions upon the federal government's own power. I think the founders foresaw that, and they provided this method in order to enable a convention to remedy that. If the only way to get that convention is to take this minimal risk, then I think it is a reasonable risk to be undergone. I suggest if the only way to clarify the law, if the only way to remove us from utter bondage to the Congress is to take what I think to be a minimal risk on this limited convention, then let's take it, unquote. Antonin Scalia's own words. My testimony has included only this one example of our opposition partially quoting a historical figure or quoting them out of context in order to make it appear that they were opposed to Article 5 conventions, when in fact, the opposite is true. We see that the opposition's claim is a lie by omission. I hope that you have found my testimony informative and helpful. Thank you for your service to Ohio and for this opportunity to address the committee.
Thank you for your testimony. Are there questions for the witness? Thank you so much for being with us.
You are welcome. Thank you.
Next, we have Diana Tellis.
Chairman Peterson, Vice Chairman Thomas, Ranking Member Humphrey, and members of the committee. My name is Diana Tellis, and I'm from Westchester Township, House District 45. I'm a volunteer with Convention of States Action and seek your support of HJR 3. I do talk fast, and I've trimmed this back, as painful as that was. Washington is broken, yet clearly has no plans to address our nation's problems with permanent solutions. We look to our country's bylaws for answers, our Constitution. The state amending convention under the authority of Article 5 of the Constitution offers a safe, civil, and effective response to the country's dire situation. Please be sure to carefully consider the words of HJR 3. It is straightforward, only 4 pages. Simply put, it is an application to Congress for a state amending convention. No more, no less. This is all we are asking you to support. We ask you not to be distracted by a few objectors. The passage of HJR 3 is far too important to allow its meaning to be overshadowed by doomsday predictions designed to impart fear in the hearts of Americans. Our opponents even resort to ad hominem attacks to discredit the reputations of convention of state leaderships, as well as the reputation of our founders for hypothetically allowing a runaway convention. If legislators had to contend with such apocalyptic disinformation every time they considered legislation, they would be petrified by fear and accomplish nothing. Your focus must remain on the words of our resolution and not the fear-driven propaganda perpetuated for decades by opponents of Article 5. If our opponents cannot even get their nihilistic claims published in a reputable legal journal, reviewed by constitutional experts, then you should not take them seriously. To alleviate the worry of a runaway claim, consider the U.S. Congress is now a permanent Article 5 convention. Article 5 authorizes Congress to propose amendments to the Constitution on any subject any day of the week. So it's hard to imagine a state convention could be more irresponsible than Congress. Yet there are no dangerous near misses and crazy amendments coming out of Congress. Why not? Congress is constrained by the political realities of ratification. 38 states must pass any proposed amendment. Since 1789, in fact, Congress has proposed more than 11,000 amendments to the Constitution. Of these, only 33 have been sent to the states for ratification, and only 27 have been ratified, the ones that were largely supported by the people. Proponents of Article 5, like me, have become disenchanted with the notion of just electing the right people next time or hoping state nullification will ever make any real difference. Unlike the opponents who tout softball antidotes to our country's problems, convention advocates seek to play a strong offense in the fight for American prosperity. Regardless of political party, the results of a state amending convention can be beneficial for you and me. A reduction in federal spending will allow us to keep a lot more of our money. We can curtail the growth of the national debt, which is now on the backs of our posterity. Without real action, even social safety nets that provide critical support during financial hardship will eventually be unsustainable. An amending convention of states is a safety feature packed into our Constitution by our founders for this moment in history. It is unethical for the states to deny their constitutional authority while Washington spends our country into oblivion. You raised your right hand to uphold the Constitution of the United States. This includes an Article 5 convention of the states, which exist as part of that Constitution. Therefore, it is the duty of state legislatures to utilize this tool, not deny it. Our country still rests under the good protection of our founders' wisdom. Please believe in all the objective reasons this convention will be successful, not in the loose speculation that purports that it will not be. There were people who opposed the founders and the Declaration of Independence from Britain. The founders forged ahead anyway. There were people who opposed the abolition of slavery. Lincoln did it anyway. There were people who opposed JFK and his challenge to place a man on the moon. He issued the challenge anyway. Albert Einstein once said, "The world is a dangerous place, not because of those who do evil, but because of those who look on and do nothing." We hope you will support moving HJR 3 forward to the House floor for a full vote. And thank you so much for your time today. You've all been really good sports.
Thank you for your testimony. Representative Brown with a question.
Thank you for your testimony. You said Washington is broken. How long has Washington been broken?
It probably started as soon as the federal government was created. Yeah.
Just
Sure.
curious.
Always a power struggle. We are mankind. That's how this works.
Thank you for your testimony. Next, we have Mark Pukita. Mr. Pukita, you do not have to talk as fast, but you are welcome to if you choose to.
I'm not sure I could do that. That was impressive. Chairman Peterson, Vice Chairman Thomas, Ranking Member Humphrey, and members of the Ohio House Oversight Committee. Thank you for granting me the opportunity to speak on a subject that is very close to my heart. The Convention of States effort, particularly through the lens of entrepreneurship and personal freedom. My name is Mark Pukita, and I am a successful entrepreneur from Dublin, Ohio, House District 11, who for over 20 years grew a business from scratch into about $100 million annual revenue enterprise, doing business in over 30 states and employing almost 800 employees, associates at sale, generating more than 3,500 jobs over those years. I know of what I speak. In the next few minutes, I aim to shed light on why this movement is not just a political endeavor, but a beacon of hope for fostering innovation, economic growth, and the safeguarding of our liberties. The Convention of States project seeks to invoke Article 5 of the United States Constitution, allowing a Convention of States to propose amendments to the Constitution. The initiative is born from a desire to address and curtail overreach of federal powers, restoring the balance of government and governance as originally intended by our founding fathers. But how does this relate to entrepreneurship and personal freedom? The connection is both profound and pivotal. At the heart of entrepreneurship is the spirit of innovation and the freedom to pursue one's vision. Entrepreneurs are the backbone of the American economy, driving growth, creating jobs, and pushing the boundaries of innovation. However, the overextension of federal regulations often creates a stifling environment for these pioneers. The complexity and breadth of federal laws can hamper small businesses and startups, which lack the resources of larger corporations to navigate these waters. By advocating for a convention of states, we seek to streamline governance, reduce unnecessary regulatory burdens, and foster an environment where entrepreneurship can flourish. Personal freedom is the cornerstone of American identity. It is the very principle that has attracted generations of immigrants to our shores, seeking the liberty to shape their destinies. Yet this foundational value is under threat when the federal government grows too large and too intrusive, as our federal government surely has. The Convention of States effort aims to reinforce the rights of individuals and states, ensuring that personal freedoms are not eroded by distant bureaucracies. In doing so, it not only protects the liberty of today's citizens, but also safeguards those rights for future generations. By decentralizing power, the Convention of States would empower local and state governments to be the primary architects of policies affecting their citizens. This is particularly beneficial for entrepreneurship, as it allows for a more tailored, responsive, and efficient government. Localized decision-making better understands the unique challenges and opportunities within each community, enabling policies that are conducive to business growth and innovation. In conclusion, the Convention of States effort is not merely a political maneuver, it is a clarion call for the revival of the American dream. It seeks to create a fertile ground for entrepreneurs to thrive, unencumbered by excessive regulation, and to guarantee that the personal freedoms our forebears fought for remain intact. By supporting this cause, we champion a future where innovation, prosperity, and freedom are the hallmarks of our nation. Thank you for your time, and I urge you to consider the profound positive impact the Convention of States will have on entrepreneurship and personal freedom in America. I recommend you pass Ohio House Joint Resolution 3 from committee for deliberation by the entire body of the Ohio House. I welcome your questions if you have any. Thank you.
Thank you for your testimony. Representative Isaacson with a question.
Thank you, Chair, and thank you for your testimony and congratulations on all your success.
Thank you.
It sounds like your primary reason for testifying and for supporting the bill and the Convention of States is around deregulation and easing things for small businesses.
Correct.
So the Supreme Court just recently heard arguments on a case that would basically, if they rule in favor of the plaintiffs, my understanding is it would essentially get rid of Chevron deference, so do what you are describing in many ways. And so I guess my question for you, because it seems like if that's the goal, right, you're proposing taking a nuclear warhead to destroy a building, right? A convention of states could fundamentally alter the nature of the country, when what you want is to deregulate for businesses. And so would the Supreme Court ruling in favor of what you're describing today sort of assuage you enough to not need the Convention of States anymore?
No, and the reason for it is I understand the Chevron concept and why it's being challenged, but since the Administrative Procedure Act went into effect in 1945, we've had a growth of what many U.S. citizens don't understand is administrative courts where judges are appointed by the executive branch. So there is an overstep of the executive branch through the APA into the powers of the judiciary. So citizens like you or I, if we run into a tax issue, we go to tax court first. We're compelled to do that. If we run into an environmental issue in our businesses, we're compelled to go to the environmental court first. And if we run into labor, I mean, it just goes on and on and on. And then if we don't like the result there, then we get to go into the normal court system, part of the judicial branch. And that just puts a weight on us as citizens that's just insurmountable, because the government has the full faith and treasury of all U.S. taxpayers to fight U.S. taxpayers when there are issues like that. Chevron is not going to fix all of that. I think what we need is a balanced budget to get rid of the bloated bureaucracy, and we need term limits to get fresh blood, new ideas, and folks who are making a living off of not doing what their constituents want them to do, but what is in their best interest personally.
Follow?
Thank you for that. You mentioned the balanced budget piece, which you hadn't spoken about before. Do you have any concerns about the way that would absolutely gut our ability to fund our military and keep the country safe?
No.
Thank you. Thank you for your testimony.
Thank you all.
Next we have Patrick Claude. Thank you for being with us today.
Chairman Peterson, Vice Chairman Thomas, Ranking Member Humphrey, members of this committee. First, I want to thank you for letting me stand up. My keister is getting rather sore. My name is Patrick Claude, and I'm from Lyons, Ohio, and am represented in the Ohio House by Representative Scott Oelslager. I've been a political activist for well over 30 years, helping in various campaigns for offices at the federal, state, and local level. First, I want to thank you for this hearing, and most of all, I want to thank you for being public officials. Yours is not an easy job. It takes a lot of courage to be out on that street campaign. So thanks, all of you. Today, I'm asking for your support of Article 5, a call for a limited convention proposing amendments to the United States Constitution to rectify injuries to our liberties. There will be much testimony on this subject, but I think the essential issue before us is being overlooked. Are we capable of self-governance? Do we still believe in representative government? Are we not concerned about the consolidated powers of the federal government? Consider that 250 years ago, our founding fathers fought King George, the English Parliament, and the most powerful military in the world. Many of their fellow citizens thought it was madness to oppose the dictates of an oppressive authoritarian government. Lucky for us, they did not heed the worries of the timid, but chose to fight the right for self-governance through the consent of the governed. The result was a freedom-loving people confident in their ability to run their own lives and wise enough to be wary of consolidated power. Unfortunately, today we have a tyrannical federal bureaucracy that has its intent the destruction of these liberties by consolidating the powers of the legislative, executive, and judicial branches of government, destroying the concept of separation of powers. This principle of separation of powers and the consent of govern are essential concepts to ensuring our freedoms. Consider first, federal agencies write the rules, which is a legislative function. Secondly, federal agencies enforce these rules. This is an executive function. Thirdly, if you disagree with these agencies, they will drag you into their administrative court. They will tell you why you're wrong, potentially fine you and or throw you in jail, which is a judicial function. Think about what this might do to one of our farmers or small businessmen, owners who might run afoul of their incomprehensible rules. They will be adjudicated in their administrative courts and be judged without the right to a trial by their peers. King George and the British Parliament could only have wished to have these powers over our citizens. This brings me to my main point. Do we have the capacity for self-governance and enough concern for this concentration of powers? Are we so timid and worried that we'd rather give up our liberties to a corrupt, tyrannical Washington bureaucracy? Are we willing to strive to uphold the American dream of self-rule and secure these liberties? I'm sure you've all heard of Elizabeth Paul when at the Constitutional Convention, she seen Mr. Franklin walk by, and she says to Mr. Franklin, "What kind of government have you given us, Mr. Franklin?" Mr. Franklin replied, "A republic if you can keep it." This is the question before us. Do we continue this process of creating a more perfect union? Article 5 is called for a convention of states to propose amendments to resolve and help the consent of the governed. Again, I want to thank you for considering these issues. And most of all, I want to thank all of you for running for public office. And if there's any questions, I thank you.
Thank you for your testimony. Other questions for the witness? Representative Brown.
Yeah, thanks for your testimony. The one of the comments you made was that the federal agencies write the rules, which is a legislative function. So apparently you think that federal agencies are exceeding their authority. The fact is, the Congress of the United States, the legislature of the United States, passed a law called the APA, the Administrative Procedure Act, which governs the process by which federal agencies develop and issue regulations. And so the agencies, when they engage in rulemaking, are engaging in a power that the legislature specifically and directly gave to them to do. So I think your comment in that regard is incorrect. Do you agree or disagree with that?
I disagree. I believe that the legislators cannot sit there and transfer powers that they are obligated to have to another branch of the government.
Follow up?
It's not another branch of the government. It's a law that created. Agencies are not another branch of the government. They're all part of the executive branch of the government. The legislature has the power to enact laws, and they can delegate authority. That's constitutional. So if you don't agree, that's fine. You're entitled to your opinion.
Well, I'm entitled to my opinion, and there's quite a few conversations going on now, particularly with the Chevron decision, as exactly where this law should go. And I think that as we look at it over a period of time, the legislators should pass the laws. But what they've done is they've taken their responsibilities and they've transferred it over to the bureaucratic state. And I think that's a very serious, dangerous thing that has happened, and it needs to be corrected over time.
Thank you for your testimony.
Thank you.
So I have the time.
Stand up.
Yeah, so I have the time at 1:59, but contrary to what I said earlier, I think we have 3 or 4 more, and my inclination is just to work on through those 3 or 4. You are going to see members leave for 2 o'clock, and that's just fine. But let's go ahead and get finished. That way nobody has to worry about coming back in a couple hours. David Kelly is my next on our list. Mr. Kelly, thank you for your patience.
Thank you for your patience. Appreciate it very much. And to all the committee members, Chairman Peterson, and Minority Representative Humphrey and members, thank you. I'm David Kelly. I'm a resident of Ottawa Hills, House District 43. And my testimony is really motivated by the hope that my children, my family, and your families and all Ohioans will continue to reap the benefits of the great country that we have here. I urge your support of HJR 3 because it is apparent that our federal government lacks fiscal discipline leading to unfathomable debt. It has expanded in scope well beyond the constitutional limits, leading to excessive regulation of states and their citizens, and it enables career politicians and bureaucrats. These problems stem primarily from certain sections of the Constitution and will not be solved by electing other well-meaning people to Congress. There's thus a need for reform, and to determine what reform is needed requires a conversation. Congress could initiate a conversation on these topics and suggest amendments to the Constitution. It has not done so, and it is highly unlikely that it will do so. As an institution, Congress will never acknowledge its shortcomings or overreach, much less voluntarily limit its own power or cede control over the states to their citizens. The drafters of the Constitution anticipated this eventuality and included Article 5 to permit state legislatures to begin a conversation among the states on how to remedy problems with federal governance. As has already been discussed, each of you took an oath under the U.S. Constitution. The U.S. Constitution requires state legislatures to have very few responsibilities under the U.S. Constitution for state legislatures. Aside from managing elections, perhaps the most important responsibility for state legislatures is to call a convention of states under Article 5 to discuss constitutional flaws. It's your duty to start the conversation. And as you conduct these hearings on this resolution, you can expect a lot of fearmongers, hand-wringers, knee-knockers, and bedwetters to warn that the sky will fall and life as we know it will cease if the Convention of States is called. Tell you do not believe them. Conventions among states, though not currently common, have a rich history in the United States. The law of Article 5 has been thoroughly researched by Professor Robert Nadelson, as we've heard, and you heard from one of the preeminent researchers on this topic, Michael Ferris, today. It's well understood what Article 5 lays out. The biggest risk that you can let happen is that Congress will continue to lead us toward economic Armageddon and federal tyranny. Congress will not fix itself. So I ask you to have the courage to do that which only you as state legislators can do. Support HJR 3 so that Ohio may join other states in calling a convention of states. Please do your duty and begin the conversation. Thank you.
Thank you for testimony. Are there questions for the witness? Seeing none, we appreciate your presentation. Next, we have Teresa Ford. While Teresa's coming up, she is my favorite witness because she's from my district. So glad to have you here.
Thank you.
Please continue.
Honorable Chairman Peterson, Vice Chairman Thomas, Ranking Member Humphrey, and members of the committee. Good afternoon. I am Teresa Ford from Chillicothe, Ohio. I've been a volunteer for Convention of States for about 5 months. Thank you for allowing me to present to you today my testimony in favor of House Joint Resolution 3. I stand before you today to urge a vote and passage HJR 3, which focuses on supporting a balanced budget, establishing term limits for federal legislatures, and for limiting the overreaching power and jurisdiction of our federal government. All three of these issues are important as poor decisions by career politicians and greed create instability in our economy, business growth, and productive future for our local communities, state, and nation. Luckily, our founding fathers made a path for us to rein in the government through Article 5 of the Constitution. On January the 20th, 2021, an executive order was issued revoking the permit on the Keystone Pipeline, resulting in thousands losing their job. My 67-year-old brother was one of those whose job was affected. He now travels to Brazil to do the same job he was doing in Oklahoma. He has faced hardships such as traveling during the pandemic, added expenses, burden of being away from his wife and family, armed banditos who wanted what he has, and violence, to name a few. We are now seeing high fuel prices normal citizens can't afford, a government wanting to push electric vehicles that are expensive and not reliable in cold temperatures, plus a reliance on foreign countries such as China and the Middle East for oil. This is unacceptable. My father, who's 93 years old, served in Korea aboard the USS Kishwaukee, an AOG-9 tanker. He survived war. He survived the Oklahoma City bombing. He survived 3 heart attacks and cancer. He worries too frequently about not getting his Social Security checks and payments due to government shutdowns. This too is unacceptable. Please help us take back control of our country. What is happening currently is unacceptable. I sincerely hope you will consider and pass HJ-R3. Thank you for your attention, and God bless America.
Thank you for your testimony. Questions for the witness? Representative Skindell.
Thank you. You mentioned about, I think, your father being on Social Security. There was a prior witness that advocated that we get rid of the national Social Security system and allow states implement their own Social Security system. Do you support that proposal?
I would have to know more about that. If it would be productive and it would stay the same without government shutdowns. Too many people are relying on Social Security payments as their only source of income. And you can't have people just sitting there watching the news about government shutdowns because of overspending.
Mr. Chair, follow-up. Thank you. There are some people that believe that the Social Security system is a federal government overreach and it shouldn't exist. So you support continuing the Social Security system?
I believe right now it should not be taken away. Like I said, too many people are relying on it as their only source of income.
Representative Brown with a question.
Thank you. You mentioned that one of the issues in this country you have an issue with is reliance on foreign countries such as China and Middle East countries for oil, and we don't produce enough oil. Were you aware that in 2022, the United States was the largest producer of oil in the world, producing 18.9% of all the world's oil? Were you aware of that?
I'm aware that most of the oil that has been shut down, look at our gas prices.
And you understand gas prices
Please continue.
Are a function of worldwide markets and OPEC primarily, correct? And not the President of the United States. You know that, right?
I understand that, but I also understand that the agenda of special interest groups trying to switch over to something that is not possible, just to go electric, is just not possible.
Okay. No further questions.
Thank you for your testimony.
you.
It's great to have you up here today. Next, we have Katherine Clark.
Good afternoon, Chairman Peterson, Vice Chair Thomas, and Ranking Member Humphrey, and all the rest of the members. Let me start by saying that I'm sure that Representative Brown and I will disagree a lot.
The chair disagrees with him on occasion also.
As legislators, I'm sure, though, that you have felt the heavy hand of the federal government as it has repeatedly usurped the rights of the state. Maybe even Representative Brown, you felt that. The federal government has most assuredly forgotten that it derives its power from the states, but only because the states have forgotten that it is their job to keep a check on the federal government. When the federal government steps outside their constitutional box, no letter writing campaign, no demonstration, not even an election is going to put them back into their place. Only the state legislators have the power to control them through constitutional amendments. Today, Washington is like an unruly teenager with absentee parents, access to the refrigerator, keys to the car, and living in a nice warm home. No parents. Well, according to our Constitution, you are those parents. Please show up. I'm standing here before you asking you to be the great statesmen and stateswomen that we need right now, that we needed years ago. I cannot fix Washington, but you can. An Article 5 Convention of States is for you to enact. It is your responsibility. Indeed, it is your obligation. You find yourself here on this committee in this moment to make history. Lay aside ego, lay aside personal ambitions, lay aside political affiliations. Be great for us. Thank you.
Thank you for your testimony. Appreciate you being with us today. Next, we have Mark Maltby. And while he's coming up, I should say, I apologize, Representative Brown. I was having fun, and I have great respect for my colleague and the questions he asks. So I apologize.
And just for the record, there are a lot of people who do agree with me. They're just not in this room.
Chairman Peterson and Ranking Member Humphrey and members of the committee. My name is Mark Maltby. I live in Trenton, Ohio, and I'm in Representative Thomas Hall's District 46. I'm an owner of a small business in Fairfield, Ohio that turns 100 years old this year. I'm a volunteer with AMAC Action, and we seek your support with HJR 3. AMAC Action is an advocacy affiliate of the Association of Mature American Citizens, which has over 2.2 million member conservatives and an alternative to the AARP. Over 90,000 Ohioans are AMAC members, and I'm pleased to present our views and recommendations. We strongly support the calling of the Convention of the States for the purpose of developing a critically needed fiscal responsibility amendment to stop the Congress's runaway spending and explosion of our national debt, as well as the restraint of the federal government's overreach into matters that are the province of the states. I came of age in the late 60s, early 70s, and like many, left college, got a job, got married, had children, and focused on my family and my business and my community. Over the past few years, I've realized that I, as well as many others, had abdicated our duty as citizens and allowed our government to stray far from the dictates of our Constitution and Bill of Rights. So I'm here today exercising my duty and privilege to be heard and ask that you use your powers bestowed on you by the electorate of Ohio to save this country by voting to convene a convention of states. Our federal government is failing Americans in many ways, and national security is no exception. The Article 4, Section 4 of the U.S. Constitution reads, "The United States shall protect each state against invasion." Yet we have a federal government that is allowing an unprecedented invasion of our southern border. According to a report from 12/2/23 from the U.S. Customs and Border Patrol, illegal migrant crossings from 150 countries, and just in 2023, they outnumbered the population of 17 of our states.
According to Gordon Chang, a senior fellow at the Gatestone Institute, many of these foreign nationals are special interest apprehensions are concerning since many are single military-age males coming from countries that dislike America, such as China, over 26,000, Russia, over 12,000, Turkey, over 30,000, Afghanistan, over 6,000, just to name a few. According to former Colonel McGregor, Hezbollah, which is a proxy of Iran, has agents in sleeper cells throughout our nation just waiting to be activated. Many retired military intelligence and counterterrorism experts warn of another attack similar to 9/11. Border Patrol agents are overrun 200 to 1 in processing facilities and are beyond capacity. Not only is this invasion a national security threat, it is creating an economic disaster for our country. The annual cost of the invasion of illegal immigrants will cost the American taxpayer $451 billion per year. So add that to our $33,000 trillion national debt. Social service programs across America are struggling post-COVID to find enough funds to assist underserved Americans that are struggling to pay rent, fight eviction, homelessness, take care of their children, and afford medical care. 50 million people in the U.S. are affected by food insecurity, with children being affected the most. Our system, such as law enforcement, hospitals, courts, schools, etc., are already stretched thin and not prepared to handle this unprecedented influx. Our government is not prioritizing the needs of our Americans. How many of our constituents are getting free housing, free cell phones, free clothes, free education, free medical care, free airfare or bus fare to any location in America? This border crisis is a complete collapse of the rule of law. Our federal government is aiding and abetting organized crime, resulting in human trafficking and the important transportation of fentanyl. Fentanyl is now the leading cause of death in Americans aged 18 to 45. 60% of unaccompanied alien children are caught by cartels and exploited through child pornography and drug trafficking. It is the largest form of modern-day slavery in the world and heartless human travesty. Federal government has overreached its authority by tying the hands of Border Patrol agents, forcing them to stand down and not protect Americans. Immigration is what makes this country great, but we need a legal, orderly process that adheres to our immigration laws. 2 weeks ago, 25 state governors felt the need to sign a joint statement to support the state of Texas for stepping up to protect American citizens from historic levels of illegal immigrants, deadly drugs like fentanyl, and terrorists entering our country. While I was thrilled by their show of support for Texas, a state that has been targeted by the federal government's overreach, the blurred power of the executive branch on steroids, a bloated and power-hungry federal bureaucracy, and a federal government negligent, there were only words. It is well past the tipping point for action, and that action must be a convention of states, which will allow states to wrest back the power bestowed on them by the Constitution and fought for both on the battlefield and in our everyday lives. I thank you for allowing me to speak today, considering this issue, and most of all, having the courage and dedication to serve as elected officials.
Thank you for your testimony. Are there questions for the witness? Seeing none, we're grateful for you being here. Nancy Sewer was our. Oh, we had you first, but the first shall be last. So
Okay.
thank you for sticking with us today.
Well, we had a little bit of a time coming through some traffic issues. Somebody had pulled somebody over the side and the entire interstate shut down. So, okay. I'm not here today under the auspices of Convention of States, even though I support it, but as a concerned citizen. I've been a registered nurse for 41 years, 30 of those years as a critical care nurse. My focus has been on the U.S. Constitution and how it governs education. All of my research can be found on my Substack. My speech today reflects government overreach. And and I'm using the royal we, okay, the royal versus the unroyal, the taxpayers of Ohio are working with Act for America to remove CRT, DEI from our schools. We have right now 136,795 signatures requesting such, and we're also concerned about parental rights as well. Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. The U.S. Constitution mandates that education in every state must guarantee constitutional rights beginning with the 14th Amendment, which is providing equal protection under the law. It is the same 14th Amendment under the Due Process Clause that not only safeguards individual rights, but also explicitly protects parental authority to direct the educational upbringing of their children. This principle is further underscored by a statutory law of Congress, affirming that parents bear the primary responsibility for their children's education, while states, localities, and private institutions have the primary role for supporting parental rights. While the Commerce Clause was originally intended to regulate commerce among the states, its scope evolved over time, initially to address issues like railroad rates. It later played a pivotal role in combating racial discrimination affecting commerce within the states, as seen in the maintenance of equity requirement. However, a significant change occurred with the Democratic-controlled Congress amending the Commerce Clause under the American Rescue Plan in December of 2021 and introduced the maintenance of equity requirements, compelling the inclusion of critical race theory in educational programs. CRT, a framework highlighting inherent racial bias in societal institutions, has sparked controversy with its binary classification of individuals as either oppressors or oppressed. The change of the Commerce Clause to promote critical race theory and the diversity, equity, and inclusion raises immediate concerns because it infringes on constitutional rights, particularly those of white students. This change impacts a broad spectrum of educational institutions, from daycare centers and K through 12 to military institutions, colleges, and universities receiving federal funds. Compliance is enforced by the implied withholding of federal funds by Congress if CRT, or diversity, equity, and inclusion, is not integrated into the educational curriculum. Congress is superseding parents' rights and responsibility for their children's education by using funding to support a political ideology. Higher education faces additional oversight through accreditation processes and federal student loan availability. As stated in the opening paragraph, the U.S. Constitution mandates that parents have the ultimate responsibility for education of their children. The state's responsibility is to follow the wishes of the parents as it relates to education. What is fundamental to every citizen in the state of Ohio is best described under the Equal Protection Clause of the 14th Amendment, which provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. That's what's happening in our schools. Government overreach, particularly through the Commerce Clause, should not dictate curriculum. The legislative branch in Ohio must be vigilant in safeguarding individual and parental rights and prevent undue interference in educational matters. Notably, concerns extend beyond critical race theory, encompassing other controversial topics which have already found their way into our schools. I want to thank you for entertaining my concerns.
Representative Humphries with the question.
Thank you, Mr. Chairman, and I appreciate your comments today, Ms. Sker. Just have a quick question for you. One of the questions that was asked earlier to Attorney Ferris was what sorts of topics would be discussed by the convention delegates. And one of the things that was said was that, the language is vague, but one of the things that probably we should focus on, he'll probably correct me afterwards or
Okay.
whatever. Let me finish, and it
That's
should go
okay.
through the chair. So one of the things that was discussed was that with regard and with all of this, it should be topics that that should be focused on are ones that are realistic. And so one of the questions that I have for you is, out of all the things that we could potentially, if this was to pass, that we could be talking about, we talked about Social Security, we talked about a whole bunch of other things. The question I have is, why would critical race theory be a topic that we discuss at a convention? Like I said, there's lots of other things that we should be talking about, but things that are within books that are really barely even taught in schools anyway, to talk about at a convention is kind of just beyond me. And so I would like for you to thoroughly explain why you feel like the removal of CRT or whatever else should be a conversation at the convention. Thank you so much, ma'am.
Okay, if we were going to go ahead and talk about education.
Well, excuse me, let's please direct your comments to the chair, please.
Oh, I'm sorry. Okay. I think the best way to explain it to you is that this is a classic example of government overreach. I can't explain any more to you than that. And the reason why it's more of a problem is that, whether you realize it or not, the Commerce Clause does have 4 different areas in which the Congress cannot make changes to the Commerce Clause. And one of those, 2 of those laws, which are applicable to this situation in particular, is one, this is a non-socioeconomic matter, okay? Education has nothing to do with commerce. The second issue is that they cannot go ahead and change the Commerce Clause if it violates constitutional rights of others, and this clearly does. This is a matter of government overreach. They're going ahead and insisting that we have to have critical race theory, which, by the way, is not supported by our Constitution. This is racism to its core. It horrifies me to see what's going on in these schools, what they're doing to our children. We have a situation in Akron where they had all the white students get on their hands and knees.
So with apologies, if I could interrupt.
You want to apologize?
We are kind of far afield from.
Right, I know, but you wanted to know why. You wanted to know why. This is a classic example of government overreach.
Again, with apologies, we're kind of far afield from the Convention of States issue that this is part of this bill. There are other bills in the legislature working through dealing with this, and the testimony would probably be better directed for some other bills.
I understand that, but this is a classic example.
With no further business before us, I appreciate everybody being here. There's extensive written testimony. This will conclude the hearing. We are adjourned. Have a great day.
And folks, you have been watching a hearing of the Ohio House Government Oversight Committee in consideration of our Article 5 Convention of States resolution, referred to as HJR 3 or House Joint Resolution 3. I'm Rita Peters. I'm Senior Vice President for Legislative Affairs with Convention of States Action. And wow, that was a lot. That hearing went on for about 3 hours on just HJR 3, the Convention of States resolution. Michael Ferris got us kicked off, and He was at his finest today, giving expert testimony about Article 5 and the Convention of States process and why it's so important right now at this time in our nation's history for the state legislatures to use their power under Article 5 for a convention of the states to propose amendments on 3 topics: imposing fiscal restraints on the federal government, limiting the power and jurisdiction of the federal government, and setting term limits for federal officials and members of Congress. Now, I understand, Producer G, that we should have Mark Meckler standing by with his reaction and some comments on that hearing, and I understand that we're working on getting Regional Director Katherine Zemanek to come on as well to give some commentary. Until I see them pop up, I will just give a few of my own comments. And number one, I have to say, wow to our Ohio grassroots team. What an amazing job they did. We knew that they would. They are one of the top teams in the nation as far as being organized, as far as their numbers. They are just always, every time, professional, smart, articulate, organized. They did a great job today and made us all proud. So my hat's off to you, Ohio team. And looks like we have Katherine Zemanek ready to join now. Katherine, again, is the regional director for the region that encompasses both Iowa, where we had a successful subcommittee hearing earlier today, and Ohio. And again, this was the proponent's testimony committee hearing day. So we didn't hear from any opposition today. That'll come at a later hearing. But Katherine, how are you feeling? What were your thoughts on that 3-hour committee hearing we just watched? Katherine, are you with us? Can you hear me?
Sorry, Rita, I was getting feedback because I was watching the YouTube channel too at the same time. So I had you going twice there and I didn't want to come on until I figured that all out. Wow, just wow. I'm so proud of the Ohio team and they're just so incredibly professional. They had a strategy that they wanted to use. And of course, Mike kicked it off. Every time I hear Mike Ferris talk about Article 5, I learn something new, and I also just know that we're in this fight together, and I'm so grateful that he got us started. So yeah, the team was amazing today, and they knew what their plan was, and they went in and executed it.
Yeah, it seemed like their testimony was well coordinated. Did they spend a lot of time planning it in advance, Katherine?
They did. They've had a committee set up for quite some time. They've gotten postponed a couple times to get this hearing. So they were grateful that they found out the date. They had about a month to plan ahead. And as you heard, we certainly had folks from all walks of life with different concerns, and they voiced those concerns. And I think they really just were the voice of the people today.
Yeah. I was thinking as I watched them testify, I would be willing to bet that there is no other single piece of legislation pending in the Ohio legislature that has this many grassroots supporters who are that knowledgeable about the legislation they're supporting. I just was blown away by their level of knowledge and their professionalism. They really want Ohio to pass this resolution, don't they?
They do. They have worked so hard. We've gotten so close so many times, and they just feel that 2024 is their time. So they're going to do everything they possibly can. And it doesn't end here, as you know. We need to hear from the opponents in this same committee, and then hopefully we'll get another stab at bringing an expert in. That's usually how they do it in Ohio. They may give us the last word before they vote, but we're pretty confident that we can get this done in this House committee and hopefully get it to a full floor vote and then move over to the Senate.
Yeah, that's right. Any word on timing of when that next hearing for opponent testimony will be, Katherine?
Well, as you know, it's election time in Ohio, and so all these folks will be going home to the representatives will be going back to their districts if they're running for office. And so, Rita, it may be a while before we hear the opponent testimony, or if the Chairman Peterson, by the way, who did an excellent job today,
Yes.
if he decides that he wants to bring the committee back to hear the opponent testimony very soon, perhaps it could be early as next week, but we'll watch and see.
Okay, Katherine, thanks for joining us today. I know you've got a lot to do, so I'm going to let you get back to it. Please pass on our thanks and congratulations to the Ohio team.
Will do. Thanks, Rita.
And now we do have Mark Meckler, who is ready to join us. Mark, you watched that whole 3-hour committee hearing, as did I, and it was quite fascinating. What's your initial reaction to what you saw?
The grassroots are spectacular. I mean, it's hard to, I can't overstate this. Mike Ferris's opening testimony was fantastic. He did as good a job as I've ever seen him do. He just kind of gets better with age, and he's done a great job for us forever, but he was extraordinary. There was the back and forth dialogue for, I don't know what it was, 30 minutes, 35 minutes. Fantastic job in that, answered every question perfectly and beautifully. Master class for me as somebody who testifies professionally. I look at that and I just hope that I can do that well anywhere that I go. So seeing that's really inspiring. And then to see the grassroots follow up on it and be, frankly, just as professional and just as prepared and just as competent as Mike was extraordinary. I'd start with Bill Scott. Absolutely amazing. I mean, he really got put on the spot. I thought that he got grilled in a somewhat inappropriate way by one of the Democrats on the committee. And I was really worried. These were some difficult questions intended to intimidate and twist him in knots, and Bill didn't bite. And he handled it perfectly. I would say certainly as well as I could have handled it or Mike Ferris handled it. So that sets a very high bar for the team. And then as you roll out through the team, everybody on the team did an incredible job. Obviously, the team worked a lot in advance to prepare that testimony. I was slacking into our Slack group nationally saying, hey, this is a masterclass. We really need to get this recording. We need actual transcripts of what each person said, what their subject matter expertise was, what their bullet points are for other people to study, because any team that wants to do a perfect job on their testimony needs to watch this team. It was as good as I've ever seen. And to be clear, there are other teams that have done a fantastic job around the country. We've got some real experts all over the country now to testify. One of the things I noticed, Rita, is the difference between the testimony now and say what the grassroots testimony was like 7 or 8 years ago. And while I commend those people who were out there doing it 7 or 8 years ago, this is worlds apart. I mean, it's Little League. I was Little League back then compared to how professional everybody is now. People are well-dressed, well-spoken. They're saying the right things. They're not redundant. Everybody has what they're supposed to say written down. They understand what their particular subject matter is and their particular approach is, and they're hitting those points one by one. I also saw a couple of people do something that I think is very hard to do, is they had written testimony and they were going through it and they were saying, this one's already been addressed. This one's, I know you already heard about this. And so they were cutting out testimony as they went. It's very respectful to the committee and not easy to do. You're nervous, you get up there, you're under pressure. Having to change on the fly like that from what you have written it's a skill. And so watching these grassroots, I was so proud to see. The only low moment I would say was the very last person to testify. And she was not one of our activists. And she's somebody who's actually been kind of cantankerous and a problem in the past, tries to use our efforts to further her own efforts. It was unfortunate that we ended on that note. I hope that the committee understands that she was not one of our folks.
Yeah, I agree with that. And Mark, I just want to point out that there are some members of that team that probably were here 7 or 8 years ago, and they just get better every single year. And you're right, they are stellar. And, I want to say there was a committee hearing in Congress late last year to talk about the Convention of States efforts. And a member of that committee at one point made the statement that we claim to have grassroots, but they're actually astroturf. And I would just love for her to see what happened today in Ohio, because, and I want to make this clear for everyone watching, every person that testified, with the exception of Michael Ferris, who does work for Convention of States Action, every other person who testified is a volunteer. These are people who left their day jobs today, who traveled, some of them pretty great distances, to be at the Capitol. They're not paid. They are trained because we train them and work with them and encourage them and support them. But that's the grassroots folks, and we were so proud of them. Mark, I want to ask you a specific question because I thought it was interesting. This question came up. One of the committee members asked Mike Ferris, what could Convention of States do to help resolve the border crisis that is just raging right now on our southern border? And I know that you recently co-authored an op-ed that was published on that very topic. So I just want to give you a chance to explain how Convention of States could be the answer to the border crisis.
Yeah, we don't plan it this way, but there's so many things that we can resolve in this country by calling a Convention of States. So we see the border crisis taking place here in Texas. There's a fight about whether Texas has the right to do anything to enforce the border and enforce immigration law. There was a former case that said in U.S. v. Arizona that said states don't have the right to do that. I think the Supreme Court might have a different opinion on that right now, but we can remove all question about this. In other words, you can get into convention under the third prong of our application, which is limiting the scope and jurisdiction of the federal government. You could give concurrent jurisdiction to the states to enforce the borders and enforce immigration law. In other words, if the federal government's not doing it, or even if they are, and the states want to provide backup for that, the states should and can be specifically given the right to do that. And this is amazing. We have a current crisis. We have 19 states that have weighed in on this resolution. If 15 states join us, we could be literally in convention in 30 days. We could pass an amendment that says the states have this concurrent jurisdiction, and Texas could lock their borders down, and there would be no question about whether they had the right to do this. So we need to get into a convention of states right away, and we're working to get all these governors who are standing up with Governor Abbott. We're working to get them on board and to make sure these legislatures pass the Convention of States resolution immediately.
Absolutely. Thanks for explaining that, Mark. Thanks for being with us today. It's been a long day of hearings, but it's not over yet. Later this afternoon, we do expect to be able to bring you live coverage of a hearing in Rhode Island, of all places. There's a House committee hearing this afternoon there, so we will be streaming that live. And this is kind of breaking news, Mark, that we just found out this afternoon, and that is that the Iowa House committee, that's the full committee of the subcommittee that we heard this morning, will be having its hearing on our resolution tomorrow. That's quick turnaround. It just came through subcommittee this morning. We brought you that subcommittee hearing live with Rick Santorum. Well, Mike Ferris, who you just saw in Ohio a little while ago, is even now getting ready to fly over to Iowa so he can be there to give expert testimony for that full committee meeting in the Ohio House tomorrow. That'll be at 10 o'clock a.m. Eastern time, and we'll bring you live coverage of that as well. So anything you want to say to close us out, Mark?
Yeah, I'm really excited about Iowa tomorrow. Usually when they do something that fast, it's because they think they have the votes. I don't want to count them before they're actually counted, but I think tomorrow is going to be a great day. Today, by the way, already a great day coming out of that Iowa subcommittee win. That's our first committee vote of the year, so we won that one. So we are 1-0 on the year. It's a great way to start the year. Hopefully we get another one tomorrow in the Iowa full committee in the House. I think we had a great day today in Ohio. So it is a good year. We've got a whole bunch of states already filed. We've got a whole bunch of committee hearings on tap. We've had, I think, 28 surge events where we put our grassroots into the state legislatures. almost 300 co-sponsors signed on around the country. It's been an incredible year already. The momentum's with us. Stick with us. We're going to have a great year with Convention of States.
Amen to that. Thanks for watching, everyone. This is Rita Peters with Mark Meckler signing off.